12. Who are we missing?
Anderson.
Okay, so Senator Anderson will not be joining us today. He was scheduled for surgery late this afternoon and got moved up to early this morning. So he will not be able to join us. So who?
Mr. Chairman, everyone is present. Representative Ayer, I think there he is. He just popped on. So
okay, I thought we had everybody at one point in time. Okay, so let's go ahead and call the meeting to order. So this is welcome to the second day of the Minerals Business and Economic Development Committee meeting. Today, we're going to tackle some subjects. The first is a short-time compensation plan, which is sort of a work share idea through dealing with unemployment insurance. The next one is an originally assigned topic regarding bank and trust company amendments or cleanup. Then the third topic is out of the ad valorem lien statute late well into the 11th hour last year. A couple issues were raised. An issue was raised from the Wyoming Treasurers Association, and it was too late to correct. The bill went through, and we had given our word that we would work that as a committee and try to get that corrected this year. Then we have several updates and reports and some information from DEQ, and one on here that I think will be good for this committee is a review of AML and how that program works, and how that just because there's a few on this committee that understand that, have been through it, but there are quite a few who are on the tail end of those funds and all the federal action that had occurred. And then we've got the state coordinated EMS transport helicopter service subject that was assigned to us. And in my county, I have strong opinions about this. So we'll take that testimony. And then finally, as we said yesterday, what we'll do is handle the bill draft that Representative Burkhart's been working on. And just as a heads up, what I think we'll do is see if there's a willingness from the committee to move for a bill draft. Then we'll refine what we have in hand. If we are to move or advance forward on any bills, I really think to do it right and honor the process, we'll have to meet again. And that would be a bill we would want to tee up and take public testimony on. I don't want to rush anything. This committee, I think we were 9-0 last year on our legislation. I like those types of records out of the Minerals Committee. So those are good things to honor. So I think with that, unless there are any questions, go ahead. We had to set up a subcommittee to work on the work share issue. That subcommittee was comprised of Senator Rothfuss, Representative Duncan, Representative Furphy, and then Minority Floor Leader Conley was sort of our ex officio honorary member of Minerals. And so with that comes a great deal of responsibility, Representative Conley. So I think, I don't know, Senator Rothfuss, are you going to take the lead on this? Do you want to, I guess, first of all, is maybe explain the concept to us and the reason for legislation, and then one of you can walk us through the bill draft, and I'll leave that up to the subcommittee, however you want to, whoever wants to take that.
Great, thank you, Chairman Greer. And I'll just briefly introduce it, but I think we have John. I asked John to join us. Let's see if he's there. He is. Good. I'm going to have John Brody actually walk through the bill. It was just updated with some new changes last night based on all of the feedback that the working group put in over the last couple of days to get this bill where it's at right now, and working with Workforce Services. So first of all, I want to say to John Brody with LSO, great job, really tremendous amount of work getting this together. This is a pretty complicated little bill draft with a lot of input over a small number of days so that we could have it ready for this morning. And I think it's in great shape. So thanks for that. the concept of the work share program, I know that you're a supporter of this, and many members of the legislature are. It's just a common sense program, is the idea that it's more beneficial both for the unemployment insurance program and for the employer not to have to completely let their employees go when they're in financial hardship. So the idea that maybe a business can afford to pay 20 hours or 30 hours for employees each week for some extended period of time, continue to pay benefits, which is an essential part of this program, and certainly an essential part of the remuneration for the employees, ensuring that there's that job continuity, that they're ready to come back, and that they don't have this long-term hiatus. So with a work share program, it allows unemployment funds and takes advantage of Department of Labor allowances to provide an opportunity for employers and employees to participate and effectively be unemployed partially, so to speak, where you get a partial unemployment payment, and then you get a partial employment payment. And there is a plan that is submitted and would be with this legislation submitted to our Department of Workforce Services, laying out how that breakdown would be implemented for how long of a period of time. And so it obviously is in the advantage of both the employee and the employer to continue in that fashion rather than having complete unemployment. You'll recall, Mr. Chairman and committee, that during the legislative session, we implemented a program like this, a work share program, through the, was this 1002? 1002, I'm seeing some nodding. Okay. It was part of our 1002 bill, where we implemented this broadly without the detail and without it being a statutory implementation, but a non-codified allowance of Department of Workforce Services to implement. And this is the codification of that. You'll see that we basically looked around the country, found the best drafts of how it was implemented in other states, modeled our legislation off of the other legislation, taking the pieces that worked best for the state of Wyoming, and again, relying on Workforce Services to tell us what the best way to implement for the state of Wyoming was going to be. And with that, I turn the floor over to Representative Connolly to see what I missed, and then go to any other member of the Representative Duncan and Representative Furphy to see if they wanted to weigh in before we have Mr. Brody walk through it.
So before we, yeah, you just second Representative Connolly, and maybe Representative Connolly can address this. My understanding and research of this is it actually results in a savings to the unemployment fund. Is that correct? And go ahead, Representative Connolly.
Yeah, thank you, Mr. Chairman. And it absolutely could. But I think the committee, one of the things the committee should understand is that this is totally employer driven. And so employers make those choices, and it can result in both keeping good employees as well as savings down the road. So there's that cost benefit analysis that is done by employers with their decision whether or not to participate in the program. So just a couple of other examples from what Senator Roth has said. Imagine that it is a small business that has 10 workers, but with the downturn in the economy, the recognition of the need to kind of decrease payroll. And so right now, the option is to lay off individuals. And let's say that the employer decides that it needs to lay off 3 individuals. Those individuals will be eligible for unemployment, but then they have obligations in terms of looking for other jobs. They're not attached to that employer anymore at all. And that's it. What this does instead is say that employer can, instead of laying off those 3 people, could reduce the wages of whatever an affected unit is by 30%. And all of those, so you have the same kind of payroll trade-off going on there, but though all of those workers then become eligible for unemployment for that 30% loss of wages. That's what work share is. Now, the reason that we put into 10002 the ability for the Department of Workforce Services to kind of stand up a program immediately outside of our statutes. But the reason that we want it in the statutes is twofold. First, the feds will help out with the implementation of the program, and you'll see that as a staff note at the end with $177,000. But also, and importantly, that the feds will backfill in 100% of that unemployment that would go to individuals who are on the work-share program. And that's not available as it exists right now, or even with the ability of DWS to stand up the program. And so it's definitely beneficial to us to kind of put the specifics in our statutes, both monetarily for the state, but also for the workers. And again, remember that this is totally employer driven. It's employer driven. Employers choose whether or not to participate. They choose whether or not to stay in it. And again, it is so an employer can keep those good workers attached to that particular employer. And that employee is not obligated to do that kind of looking for another job while the employer gets back on its feet. So those are just a couple of other examples about how it works. Thanks, Mr. Chairman.
All right, thank you. Any questions on that overview from the committee? Any questions? Okay, so Representative Conley, you had made the comment, a 30% reduction in payroll. Is that, and that's a corresponding reduction in hours worked by the employees as well? Is that how that is trued up or proved, I guess?
Mr. Chairman, yes.
Okay, and then Representative Conley, one more question with that. What is included is payroll does not include benefits. That's just your gross payroll number. Is that correct?
Mr. Chairman, the provisions of STC, work share or short-term compensation, have an obligation that if an employer is paying benefits, is paying health insurance, is paying retirement, that remain the same.
Okay, that's very good. Okay.
Yeah. And again, it's for, when you imagine it, it's an employer that wants to keep those employees, and kind of continuing with those benefits is important to keeping those employees attached.
Nope, I fully appreciate the cost of bringing a new employee on and getting them trained. There's a lot of value in those employees. So, okay.
Yeah, Mr. Chairman, can I just jump in and say, I know that you've talked about you might be able to use it, but no, I've talked to kind of some small business employers kind of in my neck of the woods who also would like to use it. They don't want to lose their good employees right now, and the recognition that that might happen right now. This is an opportunity that they are very, very interested in. Also know that 27 states already have it. We're one of the few that didn't. And someone asked me why. And all I can answer is that Wyoming has always had a more robust economy than the rest of the nation. Our unemployment rate has often been a third to half. We haven't, quote unquote, had the need for something like this. Right now, we have the need for it.
Okay. All right. Well, thank you. I think then what we'll do, unless there's any questions, is Mr. Brody. First of all, where's the best way for the committee to pull up the bill draft? What are we looking at? And do we have all that? Does the committee have that somewhere? Is it on the website? Was it emailed to us so we can follow along?
Mr. Chairman, John Brody, Legislative Service Office. I've been coordinating with Mary Beth and Brian this morning to try and get the bill sent to the committee and put up on the website. I guess I'm not on that end as far as making the logistics or satisfying those logistics. So if Mary Beth or Brian can comment, and if that's been accomplished, I just don't know at this point.
Okay, I just see that I had an email. So what I've got is 20 LSO 0735 working draft 5. Is that correct?
Mr. Chairman, no, it should be 20 LSO 0732 version 3 STC program.
Oh,
And Mr. Chairman, this is Chris. I sent out an email to the committee moments ago, well, 8 minutes ago, 10 minutes ago, something like that, that has this most recent draft, the working draft 3 in it.
Okay.
And I was just checking to see if the working draft 3 is on the web. Working draft 2 was previously on the web, but and I asked that be updated. I assume it probably is, but haven't gotten there yet.
Okay, so I have an email, members, from Senator Rothfuss at 8:21. With that, Mary Beth, is that?
Mr. Chairman, we're working on updating the website right now with version 0.3.
Okay, so Mary Beth just sent us one. So committee members, so 20 LSO 0732 working draft 3. So all the committee members have that. Okay. Duncan, or Representative Duncan, do you have it? Okay. Representative McGuire?
And Mr. Chairman, for those following along at home, it is now on the website. You'll see it as 8-01 CARES Act Short Time Compensation Plan, Bill Draft 20 LSO 0732 version 0.3.
Okay, we should all be then literally on the same page. All right, Mr. Brody, proceed.
Thank you, Mr. Chairman. Just at the outset, I just want to, on the idea of being on the same page, this bill has been a bit consuming these last couple of days, and I woke up at 1 o'clock in the morning realizing that there was an edit that needed to occur, purely technical, to the bill, which may have changed line numbers. So I would just, I guess, ask all the members of the committee to please use the draft that is on the web or that was sent out by Mary Beth, and not from Representative Rothfuss, just on the off chance that there may be a line shift due to one of those technical corrections that needed to occur.
Okay. All right.
So if you'd like, I can continue.
Yeah, go ahead, please.
All right. So as was mentioned, the STC program is a layoff aversion program, and an employer would use this program and submit a approved plan. This plan would reduce the hours of work for a group of workers in an affected unit, and these workers would in turn receive a reduced unemployment benefit payment. The STC program has, as a concept, I guess, or as an approach that states can use, has been around for a good number of years. The most recent kind of update for this program was part of the Middle Class Tax Relief and Job Creation Act in 2012. And then again, this type of program is part of the CARES Act that was pushed out in response to the COVID-19 pandemic. Through the CARES Act, the federal government is offering 100% reimbursement to states that have statutory programs in place. So that is the purpose of this bill. The agreement that the Department of Workforce Services could have entered into as a result of, I believe it was Senate File 1002, that only offered 50% reimbursement because it wasn't a permanent statutory program. So that is one of the reasons for this bill. As part of the CARES Act, the Department of Labor was tasked with providing draft language to the states. One of the reasons for that is that in order to receive reimbursement and be eligible for grants, the Secretary of the Department of Labor has to certify the state's statutory program. So just after the CARES Act was signed and authorized, LSO did a bunch of research and looked at other states that had programs in place, trying to prepare for a draft bill. After that research was done, Department of Labor issued guidance that provided the language that they would prefer to be in an STC program. The language is the same language that the Department of Labor recommended as a result of that 2012 act that I just had mentioned. For that reason, this bill is largely a reflection of the STC language issued by the Department of Labor. So there are going to be areas in this bill where there wasn't much, I guess, rationale for LSO to include it other than the fact that the Department of Labor said they wanted in there. And to disinclude it could potentially risk that the program not be certified by the Secretary of Labor. I just wanted to kind of lay the groundwork for the bill as we go through it. So page 1, you just have your bill title and description, and then beginning on page 2 is where the bill starts. So under the definitions section, subsection A, affected unit. This is basically just a description of the subset within a business that would be the subject of a short-time compensation plan, where the employees within that affected unit would have their hours reduced, but still maintain employment. Kind of the bread and butter of what an STC program is all about. Paragraph 2 defines director. The reason the director is specified is that, and you'll see this later in the bill, but the director of the Department of Workforce Services is responsible for approving any plan that is submitted by an employer who wishes to participate in an STC program. They can also obviously delegate that task to someone within the department as well. Health and retirement benefits. This is what Representative Connolly alluded to. You'll see later in the bill that it's these type of benefits that have to be, continued to be provided to the employee. And this is specific language from DOL on what those types of benefits actually mean in regard to the Internal Revenue Code. So moving on to page 3.
Mr. Chairman.
Line.
Oh, sorry.
That's okay.
Yeah, Representative Burkhardt. I was reading the bill. Sorry.
Thank you, Mr. Chairman. John, just a question on that. Does this mean that if a company, say, has 50 employees, but does not have a benefit program, they do not comply with the requirements? I just want to be clear.
Good, Mr. Brody.
Mr. Chairman, Representative Burkhardt, I don't believe so. I think what it's really a recognition of is that if these types of benefits are provided by an employer, and this employer enrolls in an STC program, that they have to continue to provide the same level of health and retirement benefits as if the person hadn't been put on a workforce aversion approach, if that makes sense.
Yes,
So if the benefits are there, then the benefits need to continue. If there aren't benefits, then my understanding is that this simply just doesn't apply.
Okay, thank you.
Okay. All right. Go ahead, Mr. Brody.
So again, on page 3, line 5, we have the definition of short-time compensation. This is just the kind of catch term of the benefits that are going to be paid to an employee or to employees under a short-time compensation plan. These are different than regular UI benefits that would be paid to someone who was fully unemployed. Paragraph 5 on line 11, this is just the definition of the short-time compensation plan, just so that everyone who's reading the statute were this to be passed would be on the same page and understand kind of what we're talking about. Usual weekly hours of work, line 17. This is just to make sure that it's clear that an employee who was working under normal circumstances, those hours are going to be the baseline under which the department would measure a decrease in hours for an affected unit. And then maybe one point to just raise here is that through this definition, an STC program can apply to full-time or part-time employees. And then obviously the time for usual hours couldn't exceed 40 hours, and it's not going to include any overtime work.
So Mr. Brody, I have a quick question, and I understand the reason regarding overtime work, but some shift work, either how it's structured by the company or pursuant to a CBA, has what is deemed scheduled overtime. With that, are we limiting with this language? Is that required by the federal statute?
Mr. Chairman, yeah. Again, a lot of this language is because the Department of Labor said the program needs to have this language. With the 40-hour work week limitation, that is straight from the guidance that was provided by the Employment and Training Administration within DOL. So I guess if a state wanted to deviate from that because of kind of maybe the unique kind of employment relationships that we may have, Department of Workforce Services could reach out to the Department of Labor and receive additional guidance on whether straying from this provision would be still acceptable and still allow for our program to be certified. However, at this point, we just don't have that guidance. So that conversation just has not taken place to my knowledge.
Okay, and I just asked that question, and I'll get to you just a second, Representative Burkhart. Just simply because I do know that in the mining industry in particular, the shift work is prevalent, and shift work typically has a component of what we use the term scheduled overtime. So Representative Burkhart, go ahead.
Thank you, Mr. Chairman. And I guess my question is very similar to yours. The companies that have what I would call alternative work schedules, they don't work a standard 5-day, 40-hour week. They've come up with alternative schedules for their work week and their hours. Would they qualify for this? Because we have a number of employers in Wyoming that do that.
Mr. Brody?
Mr. Chairman, I wish I had a real good answer with that. It really just depends on what the Department of Labor allows for. While the definition itself includes this idea of weekly hours, the substance of the definition doesn't include a weekly time period. So perhaps there's enough wiggle room in there for perhaps the Unemployment Insurance Commission through rulemaking to kind of better define how usual hours should be interpreted and whether or not it can include kind of some of the unique situations that have been mentioned as just here recently. But I can't give you a clear yes or no on whether or not those types of businesses would be necessarily included or excluded under this definition.
Okay, Representative Duncan?
Perhaps, thank you, Mr. Chairman. Perhaps, and I don't know if this makes it more difficult, but you know, perhaps it could be instead of a weekly, could it be a monthly, like an cumulative hours where it's you have 40 hours a week, but instead of limited by the week, it's that 40, and you figure out, you know, 4 weeks. So many hours a month. I don't know if that makes it more difficult, but I know for the railroad, for example, even though they wouldn't necessarily qualify in this because they have their own unemployment within their industry, but perhaps, you know, they have so many hours that they work, and it ends up being a cumulative amount. It's not per week, but it's so many hours in that month. I don't know, maybe even minors, you know, that it's so many hours in the whole month. I'm just throwing out different possibilities.
I'm going to go to Mr. Fuller, then to you, Senator Rothfuss. Go ahead, Brian.
Mr. Chairman, in response to your question, Representative Burkhart's question, I think I can offer maybe some clarity and then perhaps a question for the committee. The guidance that the Department of Labor issued provides that no reimbursement will be made for what they call seasonal employment on a seasonal, temporary, or intermittent basis as defined under state law. The guidance goes on to say if there's no definitions in state law of those terms, then they will use their own definitions. And for intermittent employment, the definition given is employment that is not continuous, but may consist of periodic intervals of weekly work and intervals of no weekly work. So I'm not sure if that starts to get at what Representative Burkhart was contemplating, but that is at least the definition included in the guidance.
Okay. Well, I think one is we're not going to make final action or take final action on this bill today, and I think we can explore that issue a little further. Senator Rothfuss, go ahead.
Thank you, Mr. Chairman. And when you look at the whole definition, it's usual weekly hours of work, and that's kind of what you're going to end up getting paid for later in the bill is a portion of that. It seems to me that this language provides the flexibility through rule and regulation for workforce services to figure out what that number is. So if I work 160 hours in a month, I think it's easy to say that's 40 hours of usual in a week. And I don't think that's stretching anyone's interpretation of the law. So I don't think it's that bad, really. I think they can work around it for the concerns that we've had raised. But I do think that if we, if we're allowed to change that language a little bit without threatening Department of Labor stamp and certification, which we want to get. I mean, I think, version 1 of this, whatever we pass, needs to be approved. Then you can go back and you can seek exception requests and try and fix it up and ask for allowances. But I want to make sure that what we pass gets the stamp from DOL so that we have the program, and then we can fight about it if we need to.
Yeah, no, I understand. I think these are really good questions, and I look to, I have a lot of family members that are coal miners in Campbell County, and they'll get laid off for a period of time, and they're still valuable employees, and they have benefits. If there's a way that they can still stay attached and then come back, this could be a huge benefit to the mining industry. And so I think what we'll do is we can reach out to their representative, and I like Senator Rothfuss's plan. It's a good one. So, okay, good discussion, committee. Go ahead, Mr. Brody.
Thank you, Mr. Chairman. And just, I guess, one more point that I could make is Department of Labor has been very receptive to states' inquiries on this program. The federal government is very, I would say, invested in this idea and is very motivated to have states provide this type of assistance. I say that only because I think we could reach out to the Department of Labor through the regional office and perhaps get some clarity for the committee that sort of leeway does exist in better defining the parameters of what usual weekly work hours are. So just to kind of, I guess, throw that out there for everyone's consideration.
Okay. All right.
All right. Moving to page 4, this is unemployment compensation. This is just I guess, to make the distinction between short-time compensation and unemployment compensation. There are different types of benefits that are payable, and this is just the more traditional benefits that would be paid under the employment security law that exists today. Page 4, beginning on line 8, this is really kind of where the meat of the bill begins. As I mentioned, in order for any employer to be able to participate in an STC program, they have to put together a plan and an application, submit that to the director for approval. So subsection A of this statute basically recognizes that fact and provides that the plan has to be in a form acceptable to the department for approval by the director. Staff comment here, this is just some feedback we received from the Department of Workforce Services. They have offered the idea of perhaps restricting the employer's approval for an STC plan to those employers that have UI accounts that are in good standing. As I note in the staff comment, this type of provision is not included as part of the language that was provided by the Department of Labor. It'd be a policy decision for this committee, but it is, I think the Department of Labor through guidance has indicated that this type of flexibility would be palatable. So if the committee did choose to go this route, I guess there's no guarantees in life, but I think the Department of Labor wouldn't have a huge opposition to such a provision. Moving on to page 5. This is the parameters of what an STC program are going to involve. So the department is tasked with developing the application form for requesting approval of an STC program and defining the approval process. And then the subsequent paragraphs go through all of the requirements that an employer will need to have as part of their STC program. Mr. Chairman, tell me to speed up or slow down as we get through this. This is a fairly long bill, so I don't want to take everybody's time unnecessarily.
Keep rolling. Okay, speed up.
So paragraph 1 simply says that the employer is going to have to describe the affected unit, the number of folks, full-time and part-time, that are going to be in that unit, and then the percentage of folks in that affected unit who are going to be covered under the STC plan. Paragraph 2 requires the employer to identify each of the employees in the unit by their name, social security number, and other information required by the director to identify the plan's participants. Again, this language is straight from DOL, so it's the Department of Labor that's requiring social security number, for example, being provided. Paragraph 3 provides that the employer has to provide a description of how the employees within that affected unit are going to be notified of the STC employer's participation. The language regarding notifying employees that are part of a collective bargaining unit is, again, from the DOL language. So it was included as a result of, I guess, DOL's insistence that it be in there. Moving to the next page, paragraph 4, here's where you would have to identify the usual weekly hours of work for those employees that are in the affected unit. And I guess this is a good point to note, starting on line 7, a short-time compensation plan shall only be approved if the percentage by which the employee's hours will be reduced is not less than 10% and not more than 60%. The states who are part of these programs or who have these types of programs are not all consistent on what those percentages are. Some states have 20% and 50%, some have 10% and 50%. But through my research, it looks like the bottom is 10% and the top is 60%. So in conversations with the subcommittee on this point, the idea was to basically make it as broad as possible, at least for the purposes of discussion. So that is why we have 10% as the bottom and 60% as the top as part of this usual weekly hours requirement. Moving to paragraph 5, the employer has to certify. This is that health and retirement benefits discussion we had earlier. So the employer is going to have to certify that if those types of benefits are being provided to an employee that's part of an STC program, that the benefits will continue to be provided to that employee. So it's fairly straightforward, but just to note that. This also has, through the DOL guidance, some sort of, I guess, maybe a caveat or additions. And beginning on page 7, line 4, kind of just provides some more detail on defined benefit retirement plans. And then also requires a certification that if basically that the certification requirement can be satisfied if there's going to be a reduction in health and retirement benefits. It can occur, but it would have to occur to everyone and not just the employees who are participating in the STC program. So if an employer had intended, or as a result of just some sort of policy change, health and retirement benefits were going to be reduced, those benefits or that reduction would have to equally apply to all employees, not just those participating in the STC program. So there's a bit of flexibility when it comes to that.
Representative Burkhart.
Thank you, Mr. Chairman. John, does the program address defined contribution plans, which some companies have? While most of them do have a defined benefit, some do have defined contribution plans. Are those addressed?
Mr. Brody.
Mr. Chairman, so I believe basically the type of plans that would be at issue with regard to this bill are going to be only those two types of plans that are defined through the IRS guidelines or regulations. And those are the regulations that are provided as part of the definition of a benefit retirement plan and a health plan. So if you go to the very top of the bill, I'm sorry, Mr. Chairman, I'm working off a small laptop here, so. So defined benefit plan, pension plan would be under 414J of the Internal Revenue Code, and contributions under a defined contribution plan would be those defined in section 414I of the Internal Revenue Code. So Representative Burkhardt, I don't know if that answers your question, but I think it's pretty fairly clear as to what contributions and benefits are being referred to in this provision.
Okay. Representative Crank, you had a question? You're on mute still, Representative.
Am I there now?
Yeah, I thought I was going to have Senator Coe give you a lesson.
Yes, the space bar wasn't working. Thank you, Mr. Chairman. Mr. Brody, subparagraph B concerning the health insurance. Has any discussion occurred with the insurance providers in that you can't just change your policy in the middle of the year, or any discussion with the health insurance folks taking place?
Mr. Chairman, no, unfortunately, we haven't really had the time. This bill, I put together this bill over the weekend so that it was ready for review and discussion today, and the type of stakeholders that would want to provide comment, we just simply haven't had the time for that to occur. It's basically been a conversation with the subcommittee and then some folks over at the Department of Workforce Services to get this in the form it's currently at.
Okay.
Mr. Fuller, did you have a question? Or oh, okay. Senator Rothfuss, go ahead.
Thanks, Mr. Chairman. To address Representative Crank's question, if you read the B provision, what it's basically saying is that you're treating any employee that's on the work share exactly equivalent to any employee not on the work share with regard to health and retirement benefits. So the intent there is that from the health insurer's perspective, they wouldn't see that employee in any different way. And that's certainly the intent, is that they be treated for health insurance purposes, for retirement purposes, equal to those employees that remain full-time employees or are treated as they otherwise would have been had they remain employed. So that's kind of where this language comes in, where you have a circumstance where there's a scheduled, let's say arbitrarily, there's a scheduled increase in the deduction amount. Well, these employees would have the same scheduled increase in deduction as the other employees. They just can't be treated separately. So I don't think there's concern from the perspective of, will this work for the health insurance and retirement sectors, and how would there be any disruption? Because this language is explicitly trying to preclude the existence of any of those disruptions and says you treat them the same. I hope that helps. Representative
Duncan.
Thank you, Mr. Chairman. Also, and correct me if I'm wrong, Senator Rothfuss and Mr. Brody, but it also protects those or extends those that if you are laid off, your COBRA is going to have to kick in after so many months of not being employed. This would protect those and not force them into a COBRA situation. So this protects your benefits and actually protects you from not having to look for something else, and saves you money, the employee money and your benefits.
Okay, Mr. Brody, this hits some highlights. We'll move a little quicker. Okay.
Okay. Page 7, line 22. This is just the another certification the employer has to make that the reduction in hours is in lieu of layoffs. They would have to estimate the employees who would have been laid off in the absence of this STC plan. Page 8, line 5. This is just the kind of due diligence for the Department of Workforce Services. The employer would have to submit reports to the department relating to their administration of the plan, and then also agree to follow any other directives necessary that the department feels are important for implementing the plan and staying consistent with the requirements of this article. This line 15 on page 8 is from the Department of Labor. All the STC programs that I reviewed had this requirement, and the employer has to certify that their participation is consistent with their obligations under applicable federal and state laws. I guess it's just kind of a belt and suspenders kind of approach for the state when it comes to administering these STC programs. And then this is a requirement from DOL, is that the plan shall not expire later than the end of the 12th full month after the effective date of the plan. Again, under DOL, it can't go any further than 12 calendar months.
Yep.
Moving to the next page, paragraph 10 just again says that there can be other requirements from the department, and the U.S. Secretary of the Department of Labor would also be involved in that conversation. So, for example, the federal government believes additional information should be provided when administering these types of programs. Staff comment, again, Department of Workforce Services has offered or requested that perhaps a condition for approval of an STC program should include that the plan have been submitted and acceptable to any collective bargaining unit or unit prior to the director's approval of that plan. So perhaps the committee may want to include an additional certification that that conversation has occurred within an employer. Line 16, this is the approval of an STC plan. The director has to approve or deny a plan within writing or in writing within 30 days. The guidance provided by the Department of Labor does not dictate that 30 days be, I guess, the time period that has to be, a plan has to be approved. I just inserted that in there because we needed to start with some type of number for discussion purposes. So that number could be greater, could be less. And I think it would be appropriate if the committee decided to just give this to the Unemployment Insurance Commission to define by rule. But however, as the bill sits, it's 30 days right now.
I think this committee has found it's better over time to insert specific deadlines in the statutes, which helps things get processed.
And then, so if a plan is denied, the director has to clearly identify the reasons for the denial. Through the DOL guidance, a decision or a denial is a final decision, isn't appealable, at least administratively. But there's also kind of the allowance for an employer whose plan wasn't approved to resubmit a new plan for consideration. Under the DOL guidance, this too had a timeline attached to it. However, in internal discussions with the subcommittee, it seemed more appropriate in this instance to just allow a little bit more flexibility to the Unemployment Insurance Commission to perhaps deal with this type of situation through rulemaking authority.
Okay.
Moving to the next page, the effective date and duration. An STC plan is going to be effective on a date that's going to be mutually agreed upon by the employer and the director. And it's going to expire at the end of the 12th calendar month, as I previously mentioned. It can expire at an earlier date as agreed upon, again, by the director and the employer. And then the effective date and the expiration date have to be provided as part of the notice of approval that's going to be given to the employer for an STC program. STC programs, that approval provided by the director can be revoked, as you'll see kind of later in this bill. If that occurs, the plan is going to terminate on the date that's specified by the director. kind of the other side of that coin is that an employer can also terminate an STC program. They just have to provide written notice to the department. And then again, this paragraph C, or excuse me, subsection C on line 19 just kind of goes into the parameters of what's involved when that termination occurs. Moving to the next page, modification. This is from DOL and is a little, I guess, kind of confusing, but the Department of Labor makes a distinction between substantial modifications of an STC plan and basically insubstantial modifications. I won't go into the kind of guts of this language, but essentially a substantial modification of an STC plan is going to require director approval. And if it's an insubstantial modification, then the employer can go ahead and just make those changes. And the insubstantial is under subsection C of this provision. And then any of those kind of insubstantial changes would just have to be identified and communicated to the department, just so that everybody's on the same page. The danger, I think, is that an employer may not know what insubstantial or substantial really is. And if they think it's an insubstantial change, but the director later determines it's a substantial change, the employer can revoke, or excuse me, the director can revoke the employer's STC plan. So we do have some rulemaking authority at the end of this bill, so that may be an area either the committee wants to consider, I guess, further working on, or allow for the Unemployment Insurance Commission to tackle that. Again, I mentioned this, but the director has the authority to revoke a short-term compensation plan. The gist of this is that if good cause exists for revoking the plan, the director has the authority to do so. We provide kind of a description of what that good cause would look like. Essentially, it would be, you know, the employer submitted a plan for approval of an STC plan or program under the STC program. And if that employer has basically deviated from that plan, then, and it kind of combats or goes against the intent of why these plans are available, then the director is going to have the ability to revoke that plan. And that's kind of just what is under, you know, subsection A and B. A revocation, we just make note, is subject to review under the Administrative Procedures Act. That'd be on lines 7 through 12. Moving to 807, eligibility for short-term compensation benefits. This is kind of the other side, not the employer being part of the plan, but what the benefits are that are provided to the employees. So 807 simply puts out the parameters of how an employee will be eligible to receive short-time compensation. Again, this is pretty much verbatim from the Department of Labor suggested language for this type of statutory program. The employee has to be monetarily eligible and not otherwise disqualified for unemployment compensation. And then basically they have to have been employed in an effective unit and under an approved STC plan. Subsection B basically just makes the, I would say, clarification that there's a kind of a difference of an STC employee and a regular employee when it comes to unemployment. So subsection B just talks about availability for work and eligible or and actively seeking work, and clarifies that that sort of requirement is still satisfied for an STC employee. Subsection C just goes in and talks about that an employee covered under STC plan is going to be deemed unemployed for the week, and basically it just tries to clarify that they are eligible for short-time compensation benefits. At the suggestion of Representative Connolly, the state of Texas has this same kind of requirement, same sort of approach, but they perhaps offer a more clear explanation of how it works. So the staff comment here just provides that language and demonstrates that an individual and an employee cannot be denied benefits because they don't meet the traditional qualifications for availability for work, to actively seeking work, and refusal to apply or accept work, just because of the unique nature of an STC employee. So that's the context of that staff comment. Page 15 goes into the benefits. The benefits formula is consistent across the states and is in light of the DOL guidance. So it would be the employee's regular weekly unemployment compensation amount multiplied by the percentage of reduction in the employee's usual weekly hours of work. So that would just be how employers and the department understand how benefits would be administered under an STC program. Subsection D clarifies that an employee may be eligible for STC compensation or just regular unemployment compensation. And then the paragraphs provided under subsection B kind of just provide some qualifications for those benefits. Subsection C just requires that the benefits received shall be deducted from the entitlement amount, the maximum entitlement amount for regular compensation. That's a pretty standard provision, just so that the books, the UI books, so to speak, for the department, I guess, stay in the healthy territory. And then subsection D on page 17 just basically says the Employment Security Act is going to apply to STC plans to the extent that it doesn't conflict. So it's kind of basically just a savings provision. Staff comment here is in relation to subsection E below. This has to do with folks that have multiple employers. We'd had discussion within the subcommittee on whether or not this type of statutory specificity for this circumstance should be included in the bill. Because the DOL guidance includes this language and it's somewhat lengthy, I put it into the bill just for the purposes of discussion for the committee, and so that you'd have an idea of what Department of Labor had stated should be included. So not all states have these multiple employer provisions in their state law. Some do, some don't. So just for the committee's consideration. Subsection E basically just talks about all the different ways that an employee would have multiple employers and how benefits provided under those types of circumstances would be given to that employee who's also part of an STC program. And I won't get into the details other than point out that these percentages that are starting on page 18, the 10% is just a reflection of that earlier discussion we had on the bottom and top of what that compensation would be, whether it's 10% or 60%. So that's why the 10% is in there. So if the 10% and 60% were adjusted, this number would need to be adjusted as well. Mr. Chairman, with your indulgence, I'll just skip that and go to the kind of next relevant part of the bill. Page 19, subsection F, basically says that the employee is going to be eligible for the regular amount of unemployment compensation if they're not provided any work during a week under a short-term compensation plan by an employer, really, or any other employer who's otherwise qualified. The employee who's otherwise qualified for unemployment compensation. And subsection G again provides just some further clarification on when benefits would accrue to an employee when an STC plan is involved. 27.3.809 at the bottom of 19 and continuing on to 20, basically just makes sure that STC compensation is going to be charged to an employer's experience rating account in the same manner as any other kind of unemployment compensation. As it has been discussed, since there's 100% reimbursement under the CARES Act, the language beginning on line 4 allows for the department to relieve an employer of those unemployment charges and to not require the employer's reimbursement for the benefits that were paid if it's subject to 100% reimbursement by the federal government or as otherwise specified by law. That final or otherwise specified by law is a reflection really of Senate file, I think it was Senate file 1002, which allowed for the governor to waive the reimbursement of unemployment benefits under the COVID-19 circumstances. So this just is a reflection of that fact, and I guess clarifies that that authority is available.
Representative Henderson?
Thank you, Mr. Chairman. It's my understanding that these dollars that are allocated for assistance under the CARES Act are separate from and not connected with, the other dollars that we received. Is that clear? I mean, is that correct? Thank you.
Mr. Brody, if you know the answer to that?
Mr. Chairman, Representative Henderson, you are correct. The money provided for these STC programs, whether it's through the reimbursement dollars that are given to states or through the money that's provided for the grants, are separate from the state funds that all the states received and that were part of the efforts of the legislature during the last special session. So yes, these are separate pots of money.
Okay. All right. Speed us up, Mr. Brody.
We're almost there.
You're running way behind. All right.
I apologize.
No, you're doing a good job. You're doing a good job.
Line 25, page 20 just talks about extended benefits. Basically, extended benefits are provided to employers that exhaust their regular benefits. So this provision is just in there to provide clarity on how extended benefits apply in the context of short-term compensation programs. Moving on to the next page, section 2, these are just conforming changes that are being made to existing statute to reflect that this new body of law is being created. And then section 3, this is worth a little bit of discussion. Section 3 acknowledges the fact that the Department of Labor will be going out or could go out to the Department of Workforce Services could go to the Department of Labor to receive grant assistance. This assistance would be for the implementation of an act or to kind of further develop a STC program. So that language is, we actually have this language. I sent it to some of the folks in fiscal to make sure that they were comfortable with the language. In the committee's consideration, I would just ask that perhaps LSO be given the flexibility to maybe modify this language as necessary without really obviously changing the intent, depending on how the committee decides.
Okay.
The staff comment just provides some context. So it provides kind of how these grants are being provided to states. Wyoming is being provided $177,037 for the grants that are available to states. That's our portion. The kind of caveat is that our program has to be in place for at least 5 years. It says that it can't be just a temporary program in order to receive these funds. If the program were to be, I guess, terminated prior to that 5-year, it's pretty clear that the Department of Labor will then come and want to get that those funds that were sent to us reimbursed. And then part of the discussion with Department of Workforce Services is that they have it is their belief that they will need another at-will contract employee to set this program up. They anticipate for about 2 years, this employee may be necessary just while they get the hiccups of the program worked out. After that point, they believe, and I guess I don't know if Department of Workforce Services is on the meeting, but my understanding is that once that 2-year period has expired, they believe they can kind of just administer the STC program under current staffing levels. So that's just a comment in regard to Department of Workforce Services staffing. Section 4, I mentioned this just gives the Unemployment Insurance Commission or clarifies, because they already have the rulemaking authority, but it says that if there's any rules that need to be promulgated, then they shall do that. Section 5 just makes the bill effective immediately. And Mr. Chairman, I'm finally done, so I apologize and appreciate the time of the committee.
Well, Mr. Brody, you did a good job. His long bill is a great explanation, and we appreciate your hard work. Committee, any questions, Mr. Brody? Okay, well, I think let me ask with LSO, Brian, do we have anyone that has signed up for or is in the waiting room to testify on this?
Mr. Chairman, we did not
Okay.
receive any signups or have anyone in the waiting room.
Yeah, and this was sort of, this was a hurry up. It wasn't a hurry up. I mean, the committee's been working on it for a while, the subcommittee. But it was the last week addition to the agenda. Okay, so committee, what I think we do at this point is a little bit backwards, but entertain a motion for a bill draft, which we already have. And so why don't we do that? We can discuss a little bit and then how we want to proceed. So Representative Duncan, is that, she moved by
So
Representative?
moved.
Is there a second? Okay, by Representative Henderson. So any questions on moving for a bill draft? I guess what my thoughts are is that we move a bill draft, we're already down that path. Let the subcommittee maybe let this soak in just a little bit. I'm still waiting on direction from Management Council. If a special session is scheduled end of June or in August or whatever the case may be, we will have to ask for another meeting. And at that time, we would open it up, take some public testimony, and then finally work the bill and then kick it out as a final minerals bill. Does everybody think that's the right way? I'm seeing a lot of head shaking. Senator Coe, you're the old dog. I want your approval. Okay. All right. Thank you. Okay. So with that, then Senator Rothfuss, question. Yep.
Thanks, Mr. Chairman. I would ask the committee if anyone sees any glaring flaws, anything they're concerned about that we could tweak or something before we worked this in the future. I think it's in pretty good shape, but I was curious if anyone had anything that came to mind immediately.
One of my comments, and then is I would not worry about getting approval regarding anything under CBA. An employer has to have those communications, and I'm afraid that that's going to require bringing another party in on certifications or modifications down the road. Let that work between the employer and the collective bargaining units, my thought. So Representative Conley?
Yeah, thank you, Mr. Chairman. And though I appreciate what you're saying, honestly, DWS did a good catch there. That was standard language that was in the DOL directive. And so honestly, I think it's just a clause that got dropped. And so thinking that it really doesn't make that much difference, but it is part of the DOL directive, would you have a problem with that?
Well, I guess, I'm going to go along the path of whatever is safest to get this approved. I just know that, because you're not going to take union employees and make them part-time without having reached an agreement with the union, any event. As long as then anytime you do a modification or a move after that, that you don't have to bring another party to the table, that is where my concern would come in. So, okay. All right, any further questions on that? Let's go ahead. We can vote by a raise of hands for a bill draft and to let the subcommittee refine that. All those in favor? So I'm seeing 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. That's unanimous. So, all right, that means no one's opposed to it. Okay. Well, Mr. Brody, thank you for your hard work and dedication. I know during these times, we've got a lot of legislators working overtime, but LSO is working double overtime for us, and we do appreciate it. Representative Conley, thank you for your work on this, and congratulations on being an honorary member of the Minerals Committee temporarily. It is truly something special.
I am deeply honored, and thank you so much.
Okay. Then with that, folks, unless committee has any further comments, we'll move along to the next agenda item, which is banking and trust company issues. And we should have received a couple of proposed drafts and then an explanation. I see we have Mr. Forkner, and it does not look like Chris Land there. So
Chris Land is, yeah, we have him in the room. This is Joe Connery, he's our deputy commissioner on our non-depository side.
Okay, I'm getting a little bit of echo, Mr. Forkner. So can everybody hear better, or is that just me? Okay. Well, Mr. Fortner, I'll let you go ahead and do the, introduce this, this topic for us and what you're looking at. And I know we've received a few comments, so I think there's some work to do moving forward, but we appreciate you getting things teed up for our first meeting. Thank you.
All right, thank you, Mr. Chairman. Yeah, Albert Fortner, Banking Commissioner. With me is Joel Mulberry, Deputy Commissioner, that oversees our what we call our non-depository unit, which would include all of our consumer finance laws and regulations in that area. So the interim topic request that was done during the end of the session seems like a lifetime ago, given all that's transpired in the last few months. But so wanted to highlight what we were looking at before COVID-19 changed all of our lives. But we had, well, one, I should say, there are no SPDI, there are no blockchain, and there's no amendments to the UCC. So hopefully we've got all of that squared away and back to some more traditional type activities, but who knows?
I'm just going to say yet.
Yeah, exactly.
Yeah.
Yeah.
Hey, Representative Burkhart, can you take the helm? I'm going to get another cup of coffee real quick.
Yes, Mr. Chairman.
Okay, thanks.
So anyway, the three items that we brought before the committee and want to work on are just some updates. The trust legislation proposal you see before you, it contains a couple issues that actually arose late last year, kind of too far into the interim last year to give it, and even into the session to give it its due course and able to discuss and vet the topics solely. So that's what we have there, and what we can go into that in a minute. The other proposal actually came out of the session. There were some changes that were made to the Money Transmitter Act, the Wyoming Money Transmitter Act. Some things that when that bill came forward to during the session, we thought of a couple other items that we were hoping to change on the fee structure to be a little more consistent with other states, as well as addressing the evolution in the online money transmission space, which we currently don't contemplate in our statutes. And then the last item, and probably the most substantive, is the changes to the Uniform Consumer Credit Code, or UCCC as we call it. That one hasn't had any significant changes. We've done little bits and pieces here or there for a number of years, actually some of it dating back to its origins of the late 60s, early 70s. And so looked at that one as needing to update it as well, looking to gain some efficiencies within our office. And so that one, while we have draft language for all three, obviously these are our thoughts and proposals that would be at the direction of the committee to work with LSO, but wanted to give the members a sense of what we were looking at, what would the scope of the proposals are. Also have items for industry, those subject to the various laws to have something to chew on, and then we can have a dialogue in the coming weeks. So that's what's before you. And then Mr. Land also added areas that were being repealed, so you would have that. So when you see big sections that are being repealed due to the proposed changes, you have a sense of what those look like. So Mr. Chairman, that's the high level of what we're looking at. And if you'd like, we can do to get everyone back on track, we can do just a brief overview of each proposal, or I'll leave that up to how you'd like us to handle that.
So what I think we'll do is just do a quick overview and the reason, this talk in terms of the reason why for each bill or each proposed bill. I think most of the comments that we received and those people wishing to comment further obviously deal with the Consumer Credit Code. I think that's probably the most significant issue of that. So why don't we deal with the trust code amendments, money transmitter amendments, and then do the commercial code last, so that's fresh in our mind. Take our public comment, have you standing by. Does that sound like a good plan for you?
Perfect, Mr. Chairman. So,
okay.
So the proposed changes to the trust company statutes, the biggest change, which takes up the bulk of the proposal in front of you, is putting in guidance dealing with mergers and acquisitions of trust companies. We realized that was missing. We have that in our banking statutes, and as you remember, last year, I guess 2018, when we did the big overhaul of 2019, whatever that was, the big overhaul of the trust company statutes and restructured them. We didn't really contemplate mergers and acquisitions. So we actually have a Wyoming chartered company that's looking at that and realized that we've got a kind of a gaping hole and no direction there. So that's that proposal. I will mention, Mr. Chairman, that Wyoming has a fairly new association, Wyoming Trust Association. We've talked with them. We'll continue to talk with them. They're going to operate very similar to the Wyoming Bankers Association in the sense that it's their representatives of that industry. We now have 17 companies. I have another application on my desk, and we expect 1 or 2 more this year. So we'll have 20 companies very likely by the end of this year or early 2021. To put that in context, we only have 25 banks that we regulate, so that the trust company business continues to grow. So that was the reason behind there is looking. So when we expect this to continue. The other thing is the state banking board. Many of you might be aware there's a board appointed by the governor. It's an 8-member board currently. They review and approve at a public hearing all public charter applications, whether it be a bank or a public trust company. And again, given the growth in the trust company space, we are proposing and have talked to the board about this, expanding it to a 10-member board, which would have 2 trust company professionals as represented on the board. So that was the proposal there. We tweaking the language just slightly on the existing members because we're getting fewer and fewer national banks in the state. There's only 5 left. And so we're having a harder time, as you said, the governor's having a harder time finding members to fill the national bank seats. So they all agree that maybe it should just be a representative of state or national without any sort of specifics. The pages 5 and 6, bankruptcy court versus receivership. This is something in talking with other states that have gone through resolving a failed trust company, which hopefully we never have to deal with. But should one of those fail, the state has to resolve that company. And so there's an option to have it go to bankruptcy court. The court of expertise can manage that. It actually might be in the benefit or the best interest of the state to do that as well. We're looking into that and they can go through that process.
Mr. Fortner, on that particular question, so a creditor has a right to take an entity into a Chapter 11. Obviously, the debtor has a right to do that. What is their authority under the bankruptcy code for a regulatory agency to do that? Now, I could see if you took a company into receivership and then as the receiver petition for 11 protection. So I just had to question that. Is that I've never seen that, and I just want to make sure that is a legal possibility.
Yeah, Mr. Chairman. Yeah, so I think as the chartering authority, we can direct them to go to the bankruptcy court. We can't do that ourselves. So then they would file under that. We have certain authorities to direct the actions of the institution, and if it's failing, they can go that route. Banks aren't allowed to go to the bankruptcy. A holding company can. Anyway, so that's how that works. And we'll double check the language, but we've talked with our counsel on that we're pretty confident that there's a mechanism to do that. Again, they're the ones the company itself would be going to the bankruptcy court. It wouldn't be by us. It would be directed by us, but actually their action is how that's contemplated.
So if they do not file, what are, as a commissioner, your options are? You revoke their charter, freeze their assets? Well, I mean,
yeah, Mr. Chairman, yeah, and then we would go through the resolution process out of this office, and so then our office, the state, really bears the cost of that. And it might be that might be an option. It really also would depend on the type of company, the type of assets, how expensive we think it might be, how complex it might be. In reality, we would most likely contract anyway with a third party, like a Big Four accounting firm, something of that nature, to help with that. The FDIC actually will contract with firms of that nature as well on bank failure. So there's still that option. What we thought was that it gives a legal, though it gives a legal authority to direct, work on directing them to that. Anyway, so that's the thought behind it, and we'll continue to look at that option and make sure we've got it clarified, or if there's any other things that we need to add to that or things we hadn't considered.
Okay, thank you.
And then, Mr. Chairman, the page 6, the last, there's 2 items there. Changes to, again, we encountered in with a recent company that we had chartered. It was a family trust company. They had been, the corporation was formed in another state, and they were operating as an unregulated trust company, unregulated family trust company, which you can do in Wyoming. However, they wanted to seek a charter and subject themselves to supervision of the state. The company is sophisticated, has grown, and wanted that option. Wasn't very clear. We found I think a quasi-workable solution to make that happen, but realized that we lack some direction in recognizing companies that were formed in another state, but were ultimately the corporation formed in another state wanted a Wyoming charter. So that's what 501 and 5603 contemplate. And then the last item, again, was just some clarifying language that industry representatives had asked us to about specific to family companies being able to hold meetings either electronically, as we are today, or in person. And so that just authorizes that and recognizes that ability.
So, committee members, any questions on the trust company? Yeah, Representative Furphy.
Thank you, Mr. Chairman. Thank you, Mr. Fortner. Let me ask about on page 4, on line or section G. It's talking about a merging of trust companies, and it says resulting trust company may maintain no more than 2 trust company branches in other states. Curious why that would be the case and how you came up with 2.
Mr. Fortner, go ahead.
Mr. Chairman, Representative, yeah, and it was kind of based on what the types of offices and number of offices that companies currently have in the trust company space, and the branch probably isn't even the best term for it, but I guess is most appropriate that we can come up with. A couple things. There's the officials and professionals in this state, want to make sure that the branching is controlled, and so if they were to have more offices in that, we can designate them as a or a service office, a representative office type scenario, where they can't do all fiduciary activities, but they can do administrative actions. The 2 was thought that would be flexible enough to, if a company that they acquire had a branch or representative office, then when you combine those 2, you could run potentially 2 branches. And again, it was a way to allow those offices to still exist, but to not open up branching. Like I said, most of the representatives in the state were not in favor of a vast trust company branch network.
Mr. Chairman,
Go
Mr.
ahead.
Chairman, I have another question. I'm just curious about, okay, if I'm concerned about Wyoming assets being acquired by, say, a federal trust company comes in and acquires one of these trust companies that we have in our state. If it's federal, what jurisdiction do you have over that acquisition to make sure it's safe for our Wyoming citizens?
Chairman, Representative, well, so if they're acquiring a Wyoming company and it say was a federally chartered trust bank that's regulated by the OCC, we'd have no authority. In fact, the same thing, there's some home host state agreements that are in place between the states. So let's say a Nebraska company acquire a Wyoming company. There might be some ways, some supervision, but it really falls to the home state almost always. And the reason they're looking at these acquisitions is usually that the entities may have a better situs in whatever state, at least the companies might feel that, things of that nature. So, but this really governs if a Wyoming company, a Wyoming chartered company under our jurisdiction seeks to acquire one out of state. And so then those assets, they would, I'm guessing they would transfer the accounts to make them Wyoming trust accounts. And therefore fall under Wyoming's Title IV, fall under our supervision of the company.
Okay, thank you.
Senator Coe. You're on mute, Senator Coe.
Yeah, Mr. Chairman, I've got to step away for about 30 minutes. I've got a conference call with Northrop and Wilmarth and Anderson about our JEC meeting, so I'll be back shortly.
Okay, thank you, Senator. Okay. Mr. Fortner, just real quick on, so we're going to move the banking board from 7 to 9 with this as well. Okay, and that, it's sort of a little bit outside the scope of, I guess I'll have to talk with Brian Fuller on this, but outside of the trust company amendments, is that?
Well, Mr. Chairman, the thoughts are that because they're, we're seeking to add trust company representation on the banking board, that it would be germane to this. And now I guess if fellow so says otherwise, but that was the thought there, just because they are specifically representative of institutions that fall under Chapter 5.
Okay, yeah, thank you. All right, and then I guess I still have a question maybe for Brian, and I get confused on this. If we're going to appoint 2 more people by the governor, they have to be confirmed by the Senate. Can we do that in advance of the bill going into effect?
Mr. Chairman, Mr. Chairman, all these appointments are done by the governor.
Right.
And so, yeah, there shouldn't be. There's no Senate. Yeah, there's no yeah, I guess there's no confirmation on this. Is what I should have said. Yeah, there's no Senate confirmation on any of these board members.
So
other than just technically the director of the Department of Audit, who's ex officio, but the board itself does. None of those are Senate confirmed.
Okay, so these don't require Senate confirmation.
Correct.
Oh, okay. So that answers that question. So, okay, you agree with that, Brian?
Mr. Chairman, there's nothing in that section that I see that requires Senate confirmation. Generally, it would say, you know, appointed by the governor with, you know, advice to the Senate, something to that nature. And then, Mr. Chairman, just one more point on that, going to your question. If you want those appointments to be able to take effect immediately, the bill can be drafted to reflect that.
Okay. Yeah. Okay. All right. Thank you. I just trying to get the timing down. Appreciate it. Okay. Committee, any further questions on the trust company proposed changes? Yeah, Representative Burkhart.
Thank you, Mr. Chairman. Just a kind of a process question. We have an effective date of July 1, 2021. So would we be considering this in the next general session, or if we have a special session, we're going to try to take this up then also? I would prefer the former rather than the latter.
Yeah, this would be a general session item in my mind.
All right, thank you.
Yeah. We're still trying to be a bit normal and do some of our regular scheduled work here. So, okay. Hey, why don't we talk about the money transmitter proposal, act proposal, and then go back to consumer credit code.
Okay, great. Thanks, Mr. Chairman. So this year, like I said, we had, as you all may remember, there was a legislation, a small bill that went through last session, basically providing a de minimis threshold for smaller companies. And our Money Transmission Act includes both the transmission of money as well as stored value products, gift cards, things of that nature. And so what we had thought about was the fee structure currently does not contemplate. It really is, a lot of it is based on, not solely, but it's based on delegated or authorized delegates, basically storefronts, things of that nature. You go into a grocery store and there might be say a Western Union or something like that branch there, things of that nature. And so fee structures are based on that. It really doesn't contemplate the online aspect in the level and the scope and scale that it should. And that has grown tremendously. So there's over $1 billion that are transmitted with Wyoming consumers every year. And a big chunk of that is online platforms. And so we wanted to change that structure. And like every other statute that we administer, the fee structures are set by rule. They've been evolving that way over years, and again, similar to other states. And so the thought is here is to strike the language on page, what page are we on? That's the last page. The last page, I'm kind of working backwards, Mr. Chairman, but page 4, you'll see the striking of that language, it caps it there. And the reason is, think about a PayPal or a company like that, or Google Pay, things of that nature, that transmit just massive amounts of money and have no storefront, no brick and mortar representation. They're going to pay as much as some of our smaller companies that submit a fraction. They're both paying maybe the max, but there's no way to differentiate those. So basically, small companies are bearing a much larger burden, if you will. And so our thoughts are, we'll strike that. We're already working on rules. We've been looking at other states and how they've got it set up. Actually, the big companies are comfortable with that. We'll continue to talk to them. But we're thinking that since the large companies take more regulatory resources and oversight, if you will, they should be paying more. And we might actually be able to reduce the fee on some of the smaller companies and get it more back into balance. And so that was something we contemplated during the session, but then realized it probably didn't fit within the constructs of that existing legislation. And so it was suggested that we pursue that during the interim. And so that's a big topic there.
Mr. Chairman, if I could just provide a little bit of clarification. So currently, for the entities that do business that don't use the authorized delegates, and so they do all of their business online or through mobile devices, the current structure is that everybody pays an annual license renewal fee of $1,000. Then the businesses that operate through the authorized delegate network have to pay an additional fee of $50 for each authorized delegate location, up to a maximum total amount of $6,000. And so for the largest entities that operate under this act, but don't do so under the authorized delegates, they actually only pay us $1,000 annual assessments. Whereas entities that do operate with authorized delegates that maybe do a much smaller volume end up paying $6,000 to us. So it's not equal. The smaller companies are actually paying less right now than the largest players in this market. And so that's what we're trying to adjust. I just wanted to clarify that.
Okay.
So no, unless there's any questions with that, we'll go back up and I'll just, a couple of the other things that wanted to highlight. That there were some questions about stored value and how that's used and how that also interacts with federal law. Members remember during the session we talked about, as part of that de minimis, there's FinCEN has a exemption threshold, and so federal law does recognize money transmission, things of that nature, stored value. There's a little bit of a disconnect, or confusion maybe, between how Wyoming's law used it and how that intersects with federal law. So on page 1, that we're seeking to clarify that a little bit and recognize it. So federal law doesn't say one thing and Wyoming's law says something else, and then we're sitting there trying to figure that out. So that's what was behind that. Page 2, we had some surety bond clarifying language there, and just kind of clean up a little bit. It allows them to actually get conditional approval on an application, and then go out and get the bond after that. We do that with a number of other licenses and entities which we charter, things of that nature. And then the last one, we did an amendment. We actually had to go back and look. In 2013, we had amended, the body amended the code to recognize the use of the nationwide multi-state licensing system. For those that have been on the committee for a while, the NMLS, you've heard us talk about that. That's just a portal that is, as the name implies, is done on a nationwide basis. It started out doing just mortgages. The platform expanded to do other license types. Well, we used language from our code, the authorization, and in the code, the commissioner is considered the administrator of the code. In the Money Transmitter Act, there is no administrator. It should have read commissioner. And so we're just going back and cleaning that up on page 3 there. So, and Mr. Chairman, the last one, I should point out on page 4 under examinations, we're just proposing charging for the direct cost of any exam. So all of the institutions that we charter and license either pay a supervisory for your exam fee, they get the privilege to be regulated and pay for it, and nonetheless, to add insult to injury. But nevertheless, we're changing that to where if we travel to an exam, the portion that they should be paying is only basically the travel costs. We feel that the examiner salaries and things of that nature are already covered by license fees and renewal fees and things like that. And so that's the proposal there, Mr. Chairman.
Yep. Committee, any questions? Okay, of course I have questions. On page 2, so we're roaming at 6, which are exemptions to the act. And so we had stored value in there. So now we are deeming stored value to be the equivalent of prepaid access. By removing that out of that section 6, that means all of this stored value and prepaid access, even if so that's covered. I mean, that's what this is for, but that was exempted out before if it was in the form of virtual currency. So okay, just explain that particular change.
Mr. Chairman, this is Joe Mulberry. I'll answer that. So essentially, we get this question all the time, and it creates some confusion out there as to whether stored value products are payment instruments under the Act. There's multiple definitions, and so what we're doing is we've added within the definition of payment instruments that it includes prepaid access, and then we also say the stored value, because stored value and prepaid access, they're kind of used, those terms are used interchangeably. So we're making sure that we're covering both instances of that, and we're specifically putting in the definition that stored value products and prepaid access products are payment instruments. And so when you go in there, everywhere else in the Act where it says payment instruments or stored value, because now we're putting stored value within the definition of payment instruments, we didn't want to create any confusion by having those two elements, because it still makes it look like it's two separate things. And so because of that, that's why we're removing anywhere it says payment instruments or stored value. We're now just striking out the words or stored value, because now they are clearly payment instruments as we're defining.
Okay, I see that. All right, thank you. Senator Rothfuss.
Thank you, Mr. Chairman. And Joe and Director, right below that, the Roman 8 that's suggested as a change. So this, when we worked the Money Transmitters Act with regard to virtual currencies, we explicitly included the language as amended as of January 1st, 2020, so that it was a set point for the federal regulations, so that we wouldn't have to keep coming back, so to speak, and seeing if we agree with the federal requirements under the Money Transmitters Act, and how we would be be engaging that. So you're striking it, which basically means that anytime the feds change the Money Transmitters Act or CFR 1010 100 FF provision of it, which I need to pull back up, that whether we know it or not, we're basically changing how we're being treated under that. So what are your thoughts? What are your thoughts there? We did that intentionally, and I just wanted to make sure that there was good reason for that.
Well, Mr. Chairman, Senator, yeah, so, and if you want to leave it in there, we can. So it's whether or when do you want to look back at the federal law changes? So if federal law changes, then all of a sudden we're out of date. And then as you pointed out, is that okay? Does Wyoming want to be now different than the federal statute and have a conflict? Our thoughts are on our other, so on our Mortgage Act, especially, we tie into the federal changes. And so if and when federal law changes, then Wyoming is consistent with that because we are enforcing, in essence, federal law through state authority. Now, if you want to do that, and I think this had to do with the exemption, and the thought was, if I remember well, that, well, if they change the de minimis threshold under federal law, does Wyoming want to follow that, or do we want to look at it and see, no, we like ours better? And so that would be, I think, part of it. Otherwise, to your point, yeah, it would maintain consistency whenever there's a change in federal law. So that we can leave that up to the body.
Mr. Chairman?
Yeah, go ahead, Senator.
Well, this was we just did this last year. This was our exception language that allowed us to basically say that, the small entities, for example, small money transmission would not be required under FinCEN. The concern was if the feds close that loophole or change that loophole later, then it might put some small entities into money transmitter requirement coverage that otherwise weren't before. So that's the concern, and that's why we put this in. If we have a date certain, if they didn't need to comply before January 1st, 2020, because they weren't classified as being required to need a money transmitter license prior to that date, then we're not going to make them. So I agree that in general we want to make sure we're compliant with federal law, but to the extent that Montana, for example, has opted out completely of Money Transmitters Act. That was the alternative piece of legislation we considered last year, and we thought this was a good compromise that will just basically say, look, if you don't apply under this definition, let's not worry about you. I'd much prefer if we reinstated that language. Maybe we get 5 or 6 years down the road and we want to change it again, and we do that proactively and we have a good reason. But I guess I'm concerned that we're undoing some of the good we did if we leave that in. What are your thoughts on that?
Go ahead, Commissioner.
Mr. Chairman, Senator, yeah, that's fine. Like I said, I think there's more risk that there's not a lot of downside risk because I just really don't see FinCEN or any federal legislation easing back. And so let's say, if they go the other way, say that they change the de minimis requirement or they change the registration requirements.
Right.
Well, since it's federal law, at that point, if it's more stringent, they'd say, well, we don't really care about Wyoming. You still have to register with us because they're under federal law. So there's that risk, but again, it's probably not that dynamic of a risk. So that's not a problem. We have no problems, not making that change. There's no concerns there.
Okay.
That was more, again, how we do the other language. And I know that they mentioned, we discussed that during the last session. So no concerns, and we'll make sure to note that.
Great, thank you.
So, Senator Rothfuss, the right amendment to that section may be to put the language in our statute rather than refer to the federal code, especially if we're trying to lock it to a defined statute, to a defined specific definition.
Right. Mr. Chairman, we talked about doing that. It ends up being kind of a long little passage. I did pull it back up. But the other concept is we honestly didn't really want it amended because it needs to comport with FinCEN. Yeah, and you put a limit in there, and then all of a sudden it hits the floor as a limit, and somebody says, well, it should be $2,000 or it should be $500, and we basically just wanted to say whatever the maximum exemption is under FinCEN for non obligatory regulation. Let's just go with that. So that was the justification behind it.
Representative Henderson, you had a question? Yeah, Representative Henderson.
Hey, thank you. Yeah, I agree with Senator Rosfitz on that. And I guess my question had to do with the size of the board. I can wait till you want to cover that later, but
Right now.
I agree with what Senator Rosfitz's line of thinking is there.
You want to discuss the size of which board? Go ahead.
Well, they want to go from 7 to 9 is my understanding. And I guess my question is, was there consideration given to recognizing that there may be some existing expertise among bankers who are, or financial people who are going to be comprising the existing board? So would there, instead of increasing the size of the board, be opportunity to perhaps designate one of the existing positions for the trust objective that they've stated?
Okay, so that, yeah, Commissioner Fortner, back on the trust company bill. Can you address that question?
Yeah, Mr. Chairman, Representative Henderson. Yeah, so we've talked to the existing board members. So in Wyoming, like I said, there's 30 banks domiciled in the state, 25 of them are under our supervision. And so of those 30 banks in total, I think it's 5 that exercise their trust powers, that have an active trust department. And so, yeah, they're not that you've got to manage that to have the expertise in the field, but the thoughts were here that these are representatives, because the board is made up, if you think about it, they're made up of 4 state chartered banks, 1 national bank representative, 2 members from the public at large that aren't affiliated with the bank, and then the director of the department ex officio. So the whole idea of that was, again, to get a broad representation of the various entities. Obviously, we focus on the state more than the national because we're the state regulator. So now that there's been growth in the trust company sector in Wyoming and a situs of choice in the country, the idea was to provide trust companies that are regulated and chartered by this office and actually by the board to have a representation there. So that was the proposal, to expand it. We didn't want to swap out seats, but wanted to recognize that we're quickly approaching an equal number of trust companies to banks.
Yep. All right. All right. Any other? Yeah, go ahead.
Quick follow up to that. All I was trying to posture was the relative difference between 10 people on the board and 30 entities. I know the exponential growth that you've talked about with regard to trust business, and I certainly support having enough resources to manage that. Thank you.
Okay. Any other questions on Money Transmitter Act? Okay. Commissioner Fortner, I'm not a big fan of just turning over fees to rulemaking. So, might not hurt to maybe sketch that out, how that you might want that to look in statute. I'm not saying that I'll get my way on that, but that's kind of my feeling on those.
Yeah, understood. And like I said, as we go back and look, and it's been an evolution for sure. You may recall a number of years ago, we did a revision of the banking statutes and moved everything, because our biggest fee there was already set by rule, the assessment. And then on the Money Transmitter Act, we've got fees set by rule there. And so the thoughts were, well, we're working on this one here. This is sort of the last one of what we administer, that we have the fee structure now. I totally understand your point. It is, our thoughts are that we want to make sure that there's always transparency in that process. And we have that we try to do that through the public comment. Of course, the governor's office and management council also get an opportunity to review as well. So, but no, point made, and we'll also, we'll provide what we think that looks like, effectively, because we've been chewing on it for the last year. So we've got a good authority.
Yeah, I'd just say get that sketched out as we move forward. Senator Rothfuss?
Thank you, Mr. Chairman. And one of the unique things with Division of Banking is that the fees they charge pay for the cost of the Division of Banking and are approved by those individuals through the board that they actually oversee that are paying the fees. So I think a lot of times there's a significant disconnect in the process where legislative oversight is certainly the key feedback for fees. But I do think in the instance of Division of Banking, there's more of a direct relationship, and I'm less concerned with flexibility there.
Yeah, no, that's fine. Their budget's still appropriated, and their FTEs are still approved by the legislature, and we control the funds of the state for the citizens. So, yeah. Okay, let's talk about consumer credit revisions.
Yeah, Mr. Chairman, what I'm going to do is that, again, we'll stay out of the weeds this one, but there are a lot of moving parts. We'll try to get those. I'm going to turn that over to Mr. Mulberry to kind of walk through.
Okay, Mr. Mulberry, go ahead.
Thank you, Mr. Chairman. The next bill is item 9-02 in your meeting materials regarding revisions to the Wyoming Uniform Consumer Credit Code. The Wyoming Code was adopted in 1971 and was based on the model law drafted by the Uniform Law Commission in 1968. The Wyoming Code is the body of law that provides the regulation of all consumer credit transactions being made with Wyoming consumers, except for first lien mortgage loans, which are regulated under a different body of law. The code regulates consumer credit sales transactions where retail merchants sell goods on credit, such as automobile dealerships or furniture stores, and also professionals such as doctors, lawyers, and dentists who provide financing of the sale of their services or assess a finance charge on any outstanding balances if amounts owed and billed in consumer credit transactions are not paid in full. The code also regulates lenders making consumer loans, and the loan section of the code is further broken down with specific sections relating to pawn loans and payday loans. Some of the provisions in our current law are the same as when they were drafted in 1968 and enacted in 1971, and they are in need of some updating. Some of the requirements under the code cause confusion for industry members, and in some cases, they are also confusing for our office and are not applicable to our current regulatory requirements, and we're recommending that a number of these provisions be repealed. The main areas that we're considering amending relate to licensing of lenders making consumer loans, establishing more direct regulation of the type and amount of charges that can be assessed in consumer lease transactions, changing the required manner of providing refunds to consumers of unearned fees when transactions are prepaid in full, and changing the manner of assessing the annual notification fees that are assessed under the Wyoming Code. The draft version that we've provided in our initial thoughts on the areas that we are considering for amending or repealing. This initial draft has been shared with industry representatives, and we have already engaged in conversations with them regarding these proposed changes. Based upon these discussions, there are some questions and concerns with some of the initial suggestions by industry members. I've had extensive conversations with Marsha Allen from the Wyoming Automobile Dealers Association, and I understand that she provided the committee with a written summary of their concerns with our initial draft. And we are continuing to review and discuss their concerns with them. We've also had conversations with representatives from the American Financial Services Association and members of the Wyoming Bankers Association. Also had a couple other conversations since I drafted my initial comments with other industry representatives. And so we're having a variety of conversations about what we're proposing. Based upon these discussions, we are also already considering changes to the proposed language in our initial draft. And if approved for continued consideration by the committee, we will continue to work with the industry members in an attempt to modify the draft language in a manner that is acceptable to both our office and the industry, if at all possible. From our discussions with industry representatives, there are also portions of the proposed changes that so far have not raised any concerns. We would like to continue to work along with the industry on areas of concern with these proposed changes and bring forward to the next committee meeting a proposed bill that is developed through these continued discussions. So, Mr. Chairman, that's just a brief summary of what we went through on the bill, and I'd be happy to answer any specific questions that the committee may have.
No, I think that is a very good approach. Committee, any questions? on this. So, yeah, go ahead, Senator Rothfuss.
Thank you, Mr. Chairman. I just want to be clear. So the UCC process, are all of these changes moving towards consistency with already approved UCC recommendations and what they have as their core documentation?
UCCC.
Yeah.
Yeah.
That's often a confusion. There's
Yeah.
the UCC, the Uniform Commercial Code, and the
Right, UCCC. I'm sorry, I left one
the
off.
Wyoming Uniform Consumer
My
Credit.
apologies.
Yeah.
I needed to throw one more on.
You're
I
not
hope
the
we have
first
4 or
person-
5 in some other piece of legislation. So the UCCC.
Yeah, exactly.
Yeah, my bad.
You're
Anyway.
definitely not the first
Go ahead,
person.
Mr. Mulberry.
Same question with one more C.
Yeah, go ahead, Mr. Mulberry. Yeah.
No, I was just going to say, yeah, he's definitely not the first person to confuse those two.
So I think Senator's question was, are these changes to conform to practice and update?
Well, Mr. Chairman, the uniform nature of this, this was drafted, it was uniform back in 1968 when it was drafted, and when we adopted it in 1971. We're a member of an association of various states. There's 10 other states that were part of an association that adopted the same version of the Uniform Consumer Credit Code. We get together and we meet regularly with those states to discuss regulatory issues of the Consumer Credit Code. Now, over the years where it was uniform at the beginning, and we still maintain the word uniform, as do a lot of other states, it's definitely not uniform anymore. Everybody's tweaked it over the years. We now refer to it as the somewhat similar credit code because, over the years, some people have totally deregulated their rates and charges. Others have made various tweaks. And so, some states their law looks very similar to ours still, but others that initially adopted it have just made a variety of changes. And so ours is still based upon the uniform language that was initially passed. But there's been a lot of tweaks over the years. So I would say that it's no longer a uniform type of law.
I would say, if I might add something to that, Mr. Chairman, is also in that is, again, not as to the industry, the consumer financing industry has evolved as well, right? There's online platforms. People are more as likely to go online as they are to a storefront, whether it be a bank or any other consumer credit provider. So we want to make sure that we're modern and recognize that. And also making sure that it strikes. So this is the UCCC is definitely part of the consumer protection side of our house. And we want to make sure we strike that balance to where we're doing the job as the law requires in making sure Wyoming's consumers are protected, but also not to the detriment to where either it's so restrictive that credit is limited because it's too onerous to abide by the laws, and therefore let's just not even provide credit to Wyoming consumers. But not so much that it shifts the burden away from the professionals, the fiduciaries, the financial professionals, to the consumer to go out there and make sure, if you've got any issues or refunds due to you, you're on your own, you'll figure it out. And so those are some of the areas that we're working with to make sure there's a proper balance. Like I said, not either side of the party or of the transaction should bear all of the responsibility. I think both parties have a responsibility of their own. And so those are the things we're trying to figure out, what makes the most sense for the credit providers, but yet also doesn't leave the consumers in Wyoming just out on their own to their own devices and resources to try to figure out if and when things are due back to them and things of that nature.
Yeah, go ahead, Senator Rothfuss.
Thank you, Mr. Chairman. Well, with regard to the tweaks and the differences with other states, I guess there's a couple things I'd ask then. Well, Mr. Chairman, we're not going to go through this line by line, I assume. We're just getting introduced to it, correct? Okay. All right. So then I would just ask more broadly, is there anything here that's pioneering that really sets us apart from any other state? I'll stop there.
Go ahead.
Mr. Chairman, I'm not sure. Some of the changes that we're proposing, I'm in discussion with other states. I've put out some emails to our other state regulators to ask on some of these specific things, especially some of the areas that we put out that are in question. And so as of right now, I'm not sure if we're a pioneer in some of these areas. But I'm trying to gather that information, and I'll definitely have it before the next meeting.
Okay, I'll stop there. Thanks.
Yeah, I think, and I think Senator Rothfuss and I are sensing the same thing. Is maybe more generally is this just been an in-house review of issues that you've logged over the years that need to be addressed? Are you working with an association? Are you coordinating with other states? What is the push behind the amendments, and maybe why are these specific amendments coming out? And I know you kind of covered that, but just a little more why.
Sure. Mr. Chairman, yes, I think that the way you described it, the second is this is our internal. I think when we discussed were there changes that we wanted to bring forth for the interim, we looked at each of the body of laws that falls under our jurisdiction and said, are there some tweaks that need to be made? And this was one, and the areas that we addressed seem like they're the areas that we consistently have to deal with and address with industry members. Like I said, some of the things that were drafted back in '68 and adopted in '71 is still the same language, and some of the language that was in there just causes confusion. So we find that we have to have continual conversations with people about the same topics. And so what we tried to do is to say, yeah, there's a number of those kind of issues. What are the complaints that we receive and the inquiries from consumers that we receive on a regular basis? So we tried to factor all of that in, and it was just based on our own internal look at what areas do we find under this body of law, do we find to be problematic, do we find to be outdated, and what causes us the most concern. And then we try to draft what, and address those areas in the proposed bill that we have. So it wasn't based upon, similar changes that other states or an association that's putting this forward. This is truly just our own look at the issues that we deal with internally with our administration of this act through our office.
Okay, that's helpful. Thank you. Appreciate that. This means we're gonna have to reserve a little more time at our next meeting to go through. Yeah. All right. Committee, any questions for Mr. Mulberry right now? If not, what we'll do is, Mary Beth, do we have anybody who has signed up to testify who's ready to do so?
Yes, Mr. Chairman, we have Marcia Allen. She's been admitted.
Very good. We'll wait for her to appear on screen. Right now, if not, what we'll do is okay. So Marcia Allen, I have you. Can you hear us? And there you are. Okay.
Good morning, Mr. Chairman. Can you hear me?
We can. So have you testified in front of Minerals before?
Mr. Chairman, it has been quite a while ago. So typically I don't have to testify in front of your committee, and I appreciate the time. I did submit written testimony to you all. As Mr. Mulberry noted, we have been in contact and discussing some of our concerns with this that we outlined for the committee. And really our intent was there are some significant changes proposed in what was posted on LSO site. So we just wanted that noted on the onset to be part of that discussion moving forward, however the committee chose to do so. Just as respect and time to the committee, I won't go through all of those things. I just really wanted to be here for questions if anybody had any, and we'll continue to work with the department, obviously, on some of those concerns that we had.
So Ms. Allen, could you do us just go ahead, introduce yourself, who you represent, and then go ahead and give us just a couple of your concerns, your biggest concerns, and then we'll see if we've got any questions. Does that work?
Mr. Chairman, yes, I'm sorry. Marcia Allen with the Wyoming Automobile Dealers Association, representing the franchise new car and truck dealers in Wyoming. And really, 3 of our 4 concerns require more research and investigation. Our biggest concerns started actually on pages 14 and 15, starting with lines 12 to 14, and then 29 through 41 going forward. That is in relationship to the fee assessment. Right now, it is a very confusing process, and it's a lot of back and forth. But the big change there would change the fee assessment to the initial creditor. The dealers are because they are facilitating the loans, are considered an initial creditor in that process. So, and it also goes back to who is licensed with the department, from what I understand, to who is not licensed, on who pays those fees. So the example that I gave was with one dealership. He, for the 2019 reporting period, paid $4,500 to the department in fees on loans that he facilitated. 9 of those were licensed and 9 were not. So he did business with 18 lenders. If the proposed change goes into effect where it is the initial creditor, for that same reporting period, his fees would go up more than double to almost $10,000 at $9,700. I talked to several other dealers, our very smallest to some of our larger. Those fees right now that they're paying to the banking division range from $2,000 all the way up to $10,000. So that would be a significant impact on their business. It would also, more importantly, I think, affect the consumer on the options that they would be offering to them. But this is something that we have talked extensively, or I have, with Mr. Mulberry with the department. And instead of getting really far into the weeds with the rest of that stuff, I would just leave it there moving forward and try and work with them to come up with some solutions on that.
Okay. So committee, any questions for Ms. Allen? Okay, I think you're taking the right approach with this. My understanding from the commission is they're trying to find solutions to problems that have come up over the years or have been difficult to deal with. And so I hope you continue to work with them and find the right resolution. And we'll be looking at this in greater detail in one of our future meetings. So. Okay.
Thank you.
All right.
Thank you, Mr. Chairman.
All right. Well, we appreciate your time and your comments, and also the hard work you're going to put into making this the perfect bill for us. Okay. All right. So anybody else, Mary Beth, that wishes to testify on this that's out there?
Mr. Chairman, I have no one else listed.
Okay. And I saw Dave Pickard had sent us an email with some comments, and it sounds like they're going to be working with Mr. Mulberry as well for those organizations. So you guys have some work to do, and that's good. So, okay, committee, any further comments? All right, so we'll close public comment on this issue. We've got 3 potential bill drafts in front of us, and I guess the chair would entertain motions or a joint motion to direct LSO to draft bills. Representative Duncan.
I move a motion for a joint bill draft for LSO.
Okay, so seconded by Senator Wassenberger. And so what I'm going to do is take that is to have LSO draft 3 separate bills as presented by the Banking Commission. Is that correct? Okay. All right, Representative Burkhart, I see you. Yes.
Thank you, Mr. Chairman. Mr. Chairman, on the consumer credit revisions bill, I think what I would want to see is what's drafted after the commissioner and the commission meet with the various groups that they've discussed. Every time I read this, I find more things to mark up. So I think the bill draft on that one might need to wait until they have really resolved a lot of the issues of the public. I don't want to delay the drafting, but I think the drafting needs to be based on, call it a revised working draft.
Well, no, I don't disagree. And this is not unusual for us to direct LSO to have a bill draft ready for us at the next meeting and encourage them to meet with an industry working group. We've done that many times.
Yeah.
Over the years. So yeah, Representative Duncan, did you? Oh.
Thank you, Mr. Chairman. I was just going to say that in order for consumers and industry partners to actually have any sort of a say-so or any sort of a comment, they need to have something to work from. So that's my proposal of why we need a working draft from LSO in order for them to even have something to complain or approve.
Yeah, and again, we have done this before with taking a concept, have LSO start the draft, know that we get input from industry. I don't think we really need a subcommittee on this at this juncture, and see what we have ready for the next meeting. So Senator Rothfuss, I think you had your hand up.
Thank you, Mr. Chairman. I was just going to say exactly what Representative Duncan said, which is that I think the best vehicle for that feedback is really this preliminary bill draft, and I assume there will be back and forth work between the commissioner, the banking division, and LSO.
Okay. All right. Any further comment, discussion on the motion for the 3 bill drafts by LSO for our next meeting? Okay, then let's go ahead and vote on that by a raise of hands. All in favor, raise your hands. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. That's unanimous. Okay. Senator Rothfuss, are you voting no? Okay.
Mr. Chairman, but we don't need a subgroup or a working group for any of these, but honestly, these are long and relatively complicated bills. It wouldn't be a bad idea to have one member of Minerals Committee on each of those bill threads as it's being drafted, just to stay apprised and know what's going on. I don't know what your thoughts are on that, but it might not be a bad concept to just throw someone into the queue for each of them.
Yeah, I think that's a good suggestion. And so why don't we, Senator Rothfuss, you take the lead on the money transmitter.
Sure.
Act, obviously, is your position with the blockchain. A volunteer on the trust company, Representative Furphy. I was going to just volunteer you. And then does anybody want to keep their finger on the pulse with the consumer credit revisions? Representative Duncan, perfect.
Great, thanks.
Yeah, and then if something comes up, let the chairman know. And my thoughts are is we might be able to get the trust company money transmitter done at our second meeting, but that the consumer credit revisions will probably roll into our third meeting, would be my general thoughts right now. So, okay. So with that, why don't we're running about 15 minutes behind schedule, which really isn't too bad. I mean, we took our time working that important work share bill, which was good. So let's take a bio break till 11 o'clock, and then we'll come back and start getting our reports from DEQ. And I'm sure Director Parfit can get us back on schedule in good shape. So, okay. So we'll hit back at 11 o'clock. Thanks. Hey, so Brian, you got just a second?
Yeah. And
Yeah.
we are still live streaming, just
Yeah,
FYI.
yeah. I wasn't going to say anything bad about you. So just good things. Yeah, so we've got the ad valorem issue up next. So what I'm thinking, right, is we'll have Jeremiah Ryman and I think Bill Novotny and Rusty Bell are commissioners. Bring them in. And do you want to set an overview, or I can, I kind of did as we started today, maybe just bring them in and let them discuss it. There's no reason for you to give an overview on it, is there?
It's up to you. I mean, I'm ready to give an overview of the bill draft if you want.
So yeah, why don't we do that? Let's do that. That'll be fine. Okay.
Are we ready to go now, Mr. Chairman?
Well, this waits for a couple more senators.
Okay.
There we go. There's a couple more senators, so we're good. Okay, let's go ahead and re-adjourn or go back in. I think I accidentally misspoke. Our next issue is the ad valorem tax issue. And I think as we started the morning, I kind of explained why we're looking at this. And so let's go ahead and start. And Mr. Fuller, if you just give us just a little bit of an overview of the bill draft that's before us, and then we'll go to Mr. Ryman with the Wyoming County Commissioners Association. And then I think I already saw Mr. Novotny, and I think Rusty Bell's also scheduled to appear. And then you can bring them in right now if you want as well. It's fine.
Mr. Chairman, they are in the meeting already.
Oh, okay. I don't see them on my screen. They must have.
Mr. Chairman, they just have their cameras off right now.
Very good. Okay. All right. Go ahead, Mr. Fuller.
Okay, Mr. Chairman. So members of the committee, you should have it's just 21 LSO XX draft .2 before you. And just to recap, the legislature passed Senate File 139 last year that basically for liens on mineral production that happens on or after January 1st, 2021, those liens automatically perfect upon the production of the mineral. There's also language in there regarding a notice of intent to foreclose before tax sale, and then the superiority of liens after January 1st, 2021. Specifically language about the lien not being enforceable on a new owner if the new owner certifies that at the time of the transfer all taxes were current, or there's some sort of release or settlement or agreement for the payment of those taxes. So this bill draft amends provisions that were in the 2020 bill, the one that is before you. So starting on page 3, line 14, this language regarding liens applies to those before January 1st, 2021. The stricken language was language that was inserted in 2020 Senate File 139, and it just strikes the reference to the new owner or new person extracting the mineral not being subject to a prior lien. So that language would go away. Moving on to page 4, lines 9 and 10, this is the new language for liens that are for production on or after January 1st, 2021. It strikes language on lines 9 and 10 regarding a reference to superior liens existing before January 1st, 2021. And then beginning on line 12, it strikes that that language that was inserted that references a new owner or new producer not being subject to a prior lien. So that language would go away. And then, Mr. Chairman, based on direction from the chairman, there's an alternate version to subparagraph C that is included in the staff comment on page 5. In terms of a new owner, it would just provide that, the new owner has to certify that the county holds no liens that are imposed on the production of mineral after January 1st, 2021. Page 5, lines 35 and 36 just strikes a reference to the tax sale for the notice of intent to foreclose. And then, Mr. Chairman, the bill draft would be effective July 1st, 2021. And one final comment on that. The bill as currently drafted actually contemplates that it would take effect before January 1st, 2021, when this new lien regime would come into effect. If this bill were to be considered during, say, the 2021 general session, then it would need to be amended to reflect that period of time where this current statute language would be in effect, and then it would be at some future date that these changes would take effect. With that, Mr. Chairman, I'm happy to answer questions.
Okay. Committee, any questions of Mr. Fuller? So, Brian, before we have the discussion with the County Commissioners Association, on page 5, line 35 and 36. So President Perkins and I had a lot of discussions about this, and I agree it was awkward, but under subsection C in this section is the whole tax sale process. So what we were wanting to do is you just trigger to foreclose a lien under this is that you would go through that tax sale process and not reiterate it. So I guess my question to you as an attorney, do we still get to that same result? Would you still fall back to subsection C and that tax sale process with that being stricken? I guess, does this make this clearer, or does it make it ambiguous with it being stricken?
Mr. Chairman, I think by striking the language, there certainly could be a question whether that tax sale process would apply to foreclosing a tax lien under this paragraph, meaning foreclosing a tax lien imposed on post January 1st, 2021 production.
Okay. That was Senator Perkins and I's conclusion. So, okay. Committee, any questions for Mr. Fuller? And we can always ask him questions later. Don't worry about it. Okay, so why don't we bring in Mr. Ryman and his commissioners? Okay, Mr. Ryman, how are you today?
I'm doing well, Mr. Chairman. Really appreciate the opportunity to be with you this morning. Again, my name is Jeremiah Riemann. I represent Wyoming's county commissioners. We do have with us today Bill Novotny, who's the chair of the Johnson County Commission, as well as the WCCA treasurer. And with him is Barry Craigo, who is the Johnson County Civil Deputy Attorney. We had intended to have Commissioner Rusty Bell from Campbell County this morning, but today is a commission day, so he's involved with budget hearings there and unable to join us, and he sends his regrets. Mr. Chairman, with your permission, what I'd like to do is just quickly go through the 3 changes that are proposed here and a little bit of background on why those are requested, and be happy to take any questions that you or others might have.
Go ahead, Jeremiah. I think that's the appropriate way to go. Yeah.
Great. Mr. Chairman, committee members, as LSO stated, this is a bill amendment to something that you just passed. At the final hours of this last session, there were a few things that we identified, and these are those that we would like to see corrected the timing wasn't perfect in order to advance these. And so we agreed to come back in this interim to try and address them. So Mr. Chairman, I'm going to jump ahead to page 3 of the draft bill, starting on line 14. And I'll talk about this, but this provision also, again, comes up in the post January 1st, 2021 language that you find on page 4, starting on line 12. So I am trying to address both pieces as it comes up there. As is related in the LSO memo that all of you received, this bill does allow for a company that is purchasing assets to receive a certification through that sale from the existing owner that would suggest that taxes are current, and thus they would not be, the lien that the county would perfect under this would not be enforceable moving forward. So why is that a problem for us in this bill, and why do we ask for the deletion of this language? Well, in terms of current process, any individual could go into a county treasurer's office and ask for a certification that they're current on their taxes. And assuming that you've paid your taxes up to that point, you've complied with the deadlines that are set, and we just passed one of those on May 15th, then you would receive that certification. The issue that presents itself is that in terms of mineral ad valorem, there is still tax owed at some future point because of the lag that exists in the collection system. So we could put ourselves in a position where county treasurers are issuing certifications that are true and valid relative to tax payments up to that point in time, and potentially giving authorization that the existing lien for that production in the period that hasn't been taxed yet is not enforceable, and that's an untenable position. So the first solution that we presented to the chairman was to delete this language. As was referenced by LSO on page 5 of the draft bill, is another alternative that we did work out with the County Treasurers Association of some language that could be alternatively put into both of these places and could work for us. So we're certainly fine to accept either one of those proposals, but our first preference, of course, is to just remove this provision and let the liens that are perfected under this bill, whether that's before or after January 1st, 2021 exist. So Mr. Chairman, that's issue number 1.
Yeah, so Mr. Riemann, so the balance here, and the way we tax ad valorem presently, which is going to change over 15 years, but how we do it presently is how do you allow the sale or partial sale of assets, and so that we're not quieting commerce in terms of transfers, all for the sake of making sure we're 100% secure. And I think that I guess I was in the position of having spent a lot of my life in this session talking with President Perkins, trying to find a way to bring this forward. And so that is a concern, because you're still going to want, you don't want to get in the way of commerce, of sales and transactions.
Mr. Chairman, absolutely agree. That's not our intent here. Our intent is simply to make sure that everybody has proper notice that even if you receive a certification that taxes are current to that point in time, there is still a lien that exists on production where taxes have not been paid and will be paid in the future. It is not at all our intent to slow down those transactions and sales or any commerce that might exist.
So Senator Coe, yeah, I better let the committee members ask questions. Go ahead.
Okay, I guess, we're talking on page 4, Mr. Chairman, about a county lien and the provisions for doing that. And then we get into paragraph E over here. And now we're talking about the county treasurer who acts on behalf of the county. I guess my question is, why do you want to take out pursuant to a tax lien under subsection C of this section? It just appears to me that we'd be better if we left that in, because they both work together. The county lien and what the county treasurer is going to do. So if you could explain that to me, please.
Go ahead, Jeremiah.
Mr. Chairman, that's one of 2 issues that I still have left and I wanted to address. And Senator Coe, to your question, this is a request that came to us from the county treasurers. And as I understand the issue that exists here, it's not that we don't want to follow the tax sale provisions. It's that this provision, the way that this is structured, sets up 2 and in part conflicting provisions. So you have here, pursuant to the tax sale provisions under subsection E of this section, which of course are those tax sale provisions. But if you follow that provision to its end, it then has additional foreclosure requirements that exist upon the county treasurer. And those aren't included in this bill. You'd have to go back to Senate File 139 to find the 3 pages of those provisions. And so the treasurers are simply, as I understood it, trying to find some balance here and not have a set of conflicting principles in this section of the bill.
Okay. Let's go back though on the issue of the stricken language, and then we'll tackle that one separately, because so just Jeremiah, just so I understand, well, we're on page 3, we've got the stricken language, which is a certification from the county that that all taxes are current. That causes a problem with ad valorem because it's paid in arrears. Okay. And that's the same language on page 4, lines 12 through 22. You're saying that an alternative language is in the staff comment. So page 5, lines 27 and 28 are a good compromise with that. Okay, so that's one of 3 issues. On that particular issue, how will we deal with unpaid ad valorem if a sale is going to go forward? How does that happen now?
Mr. Chairman, that would, as I understand it, become part of the transaction. Either the selling entity would pay for those taxes that are anticipated to be due in the future, or that would be a disclosure in the agreement that the purchasing company is going to assume that liability once the transaction is complete.
So I take the assets subject to the lien. I understand that. What if it's a partial sale of assets?
Mr. Chairman, I'd have to defer to others. Perhaps Commissioner Novotny or Mr. Craigo has an answer to that. I don't know that answer.
Okay. And yeah, Mr. Craigo, I assume Mr. Novotny, you may pass the baton. However you guys want to do it, it's fine.
Co-Chairman Greer, can you hear us?
Yes.
All right, I will defer to Mr. Craigo because we've been in this situation. So for the benefit of the committee, Mr. Barry Craigo, who's the civil deputy for Johnson County, who represents us in these matters.
Yeah, go ahead, Mr. Craigo.
Mr. Chairman, thanks for the question. So the way it is handled now is all of those assets are identified specifically. So when an oil and gas transaction goes through, each site actually is assessed separately. And so
Mr. Chairman,
they
to
get-
interrupt, I can barely hear him.
Okay. Sorry. I think that's just distance from the microphone. That's
I apologize. Sorry about
that
that.
better, Representative Duncan? Go ahead, Mr. Craig.
Thank you, Mr. Chairman. So the way it is handled now is the assessor's offices have all of those assets identified piece by piece. And so if a partial sale goes through, the assessor's office can divide out where those assets are going and who they are being sold to or not sold to, depending on the partial transaction. And so it's handled the same. A partial transaction is handled the same as a complete sale of all assets.
So, Mr. Craig, for that to occur, then do I get a certificate if I'm a buyer or seller either way? But let's say just as a buyer, then I accept a certification from the treasurer's office, right?
I suppose you could, and I was going to comment on this later, but you really, the way it's handled now, so if you're a purchaser, you would call the treasurer and say, are there any taxes owed on this property? As part of your due diligence, you would do that. So the purchaser calls the treasurer, picks up the phone, calls the treasurer and says, I'm getting ready to purchase these assets. Are there any taxes due? And the treasurer will say yay or nay. But she's not, and this is, I guess, our problem, and probably the treasurer's problem with the language in the last year's bill was you're not making a certification, so to speak, because the treasurer doesn't know as far as what liens may or may not arise, because she does not know, or he does not know, what production has occurred during that calendar year, and won't until some later point. And so for the treasurers to certify that no taxes are due, I guess I don't think they can do that. The other problem is we have amendments to production reports all the time, and we taxes come in, taxes come out on a monthly basis through the county commissioners meetings and through your treasurer's office. And so we get supplementals and we get refunds, and I think it just becomes a huge bookkeeping problem for the treasurers. They don't know the answers to those questions. If they're asked to certify it, I don't think they can actually do that, other than to say, as far as they know, no taxes are due at that point in time. They could make that certification, but that would create some lag in time there where a lien may arise because the production was actually more than what had been reported, or the production actually hadn't been reported yet. And so the treasurers wouldn't have the opportunity to know that.
Okay. All right. Committee? Of course, I find all this very interesting. So, Representative Duncan.
Thank you, Mr. Chairman. So I guess my question is, forgive my ignorance here. So my question is, what is the path of the payment? So you have the entity, the mineral or the company, and they have their production. Who verifies the production in terms of for the taxes owed and due and to be paid? And how does that process work to make sure the county gets that? And in that whole process, in order for to get back to the point where we're at with a sale or a partial sale, because as I'm trying to wrap my brain around it with like a real estate transaction, we have a title company who goes through and does a title search, and they go in and they find out and they let us know if there's any liens, they let us know if there's any taxes owed, they let us know what the payoff is for mortgages, chattel mortgages, all these other things. So we know for sure because someone goes and does all this. So what's the process for these mineral companies? Because I'm ignorant in this.
Okay, let's go Representative Crank, and then I'll let you guys answer.
Yeah, thank you, Mr. Chairman. And I think I can answer a little bit of that, having been involved with some sales of coal mines before. And there's a date that's a cutoff date for the sale of taxes, they know it. And then we've gone in and actually measured stockpiles and whatnot that become part of the due diligence on the buyer and the seller to know what they're getting at the time of the sale. I can't vouch for how oil and gas might do it, but I know we've done it before for coal stockpiles and gravel piles and stuff like that.
And one thing too, the lien is, if I understand this correctly, the lien is on the produced mineral only. Is that right? Yeah. Okay. Okay. So good discussion. I don't know, Mr. Krieger, did you have any comment on any of those questions, or Jeremiah? Okay. Committee, any further? Well, go ahead.
Mr. Chairman, I would just add to Representative Crank's comments, and that there's typically on a complex oil and gas transaction, and I imagine coal is somewhat similar, there's usually a true update sometime after closing. And so unlike a house, or a piece of real estate you buy, your transaction is completed on the day of closing, period, end of story. But with a complex oil and gas transaction, based on their contract, they will go back in. They will estimate what taxes are due, and they'll allocate that figure between the purchaser and the seller. And then sometime later on, maybe 6 months, sometimes even longer, they'll have a true update where they go back in and look at what the taxes actually were. And then additional monies are exchanged, either given back or more is paid, depending on how it plays out.
Okay. Nope, I think good discussion, committee. Good.
Mr. Chairman.
Yeah, Jeremiah, you have two more issues, or you want to comment on that one again?
Well, Mr. Chairman, if I could just clean up there, and I have one more issue. Mr. Chairman, in terms of that issue, really what we're trying to prevent is a situation where a county treasurer inadvertently provides that certification that taxes have been paid without an understanding that there is some remaining tax liability here. So that's our intent with that recommendation for page 3 and 4. Mr. Chairman, the final issue that we bring to you today, and it's the most significant of these, and that is on page 4, lines 9 and 10. And that's to remove this language that says, except any superior lien existing before January 1st, 2021. And just as a little bit of background, going all the way back to the 2019 session, we worked very hard with the bankers around the state who had presented an issue that they were going to be at risk in any move to put the county in a priority position. And ultimately, the compromise was struck that we would establish this date of January 1st, 2021, which would give the bankers sufficient time to work with their creditors to address any issues that they might have. And then on that magical date, counties would then take a priority position. And so if you go back to, let me get the bill here, Senate File 118 from 2019 general session, the provision was inserted for that for any lien related to mineral production on or after January 1st, 2021, the county lien is perpetual against all persons excluding the United States and the state of Wyoming, and attaches and is perfected immediately on production of the mineral. And there are some various other provisions in that statute. What issue has been identified with the change that was made in this bill is that counties will, of course, take a priority position, but as it says here, except for any superior lien that existed before that date. So we now end up behind all of those creditors that had that priority before that date. And we may be behind them for 10, 15 years into the future. And we gain no traction. In fact, we feel we've lost ground in relationship to what we had in 2019 session. And I know that wasn't the intent. And so what we're asking is that language be stricken here and that the county be restored back to that priority position starting on January 1st, 2021. So, Mr. Chairman, the third issue that I did have was that provision that Senator Coe asked about on page 5.
Okay, well, let's talk about, let's take one issue at a time. Okay, so the 2019 had been, that language had been tried like 3 times. And then Representative Summers and I gave Representative Western an amendment to run, which he got through. That's how that language came about, third reading in the second house. So we were trying to advance the ball and move in the right direction. Read that to the committee again, because I have a real hard time with the concept of interfering with the contracts that are existing prior to this date. So he convinced me here.
Yeah, so Mr. Chairman, and I'm looking at existing statute 3913-108, and it says for any lien related to mineral production on or after January 1st, 2021, the county lien is perpetual against all persons excluding the United States and the state of Wyoming, and attaches and perfected immediately upon the production of the mineral. And it does go on subject to all other prior existing liens, and then some other language there. The subsequent provision C then has the pre-January 1, 2021 language, and has a provision in there relative to those liens, and then goes on to say, except as otherwise provided in this subparagraph, any lien arising under this paragraph related to mineral production before January 2021 is superior and paramount.
So I guess, sorry, committee, I'm reading here, but so I'm guessing when we're saying that taxes, so I'm reading the existing statute, which is what we did in 2019, which was a significant step forward. Okay, but it says here, subject to all prior existing valid liens. So so now we're coming in, to me, this is a monumental shift in policy, what's being suggested by striking that language. Tell me where I'm wrong.
Mr. Chairman, I'm going to allow Mr. Craigo perhaps to jump in here as well.
Okay, we're unmuted.
Mr. Chairman.
Yes.
So here's what I guess we'd have to say about this is that although certain parts of the 2019 statute were helpful, it still leaves us, we don't gain any traction as far as collection. And that's really what we're talking about from a county level is we're hamstrung. And we talked about this at the select committee quite a bit last year, and really what happens is for the foreseeable future, as Jeremiah alluded to, we won't be able to collect on unpaid ad valorem mineral taxes because we're, a lot of these oil and gas companies will have 2 or 3 creditors ahead of us in line, and we're not going to be able to collect. We'll have a lien, it just won't be collectible. And so our whole point was most mineral states make mineral taxes a super priority, which means they have first lien no matter what. And that's what we're trying to push for. And I think that's what Jeremiah was talking about, is there was sort of this agreement that was a date that everybody could stomach, at which point the counties would have superior lien for the ad valorem mineral production taxes. And right now, the language does not, although I think the intent was to help the counties, it really, from a practical standpoint, does not. And until we have a super priority lien, except, above all others except the state and the federal government, we're not able to do anything with these unpaid taxes.
Well, go ahead, Senator Rothfuss.
Thanks, Mr. Chairman. And Mr. Chairman, I was on that task force, and this was obviously a point of discussion of how we could lay this out in a way that was appropriate and constitutional. really to address your concerns as well, which is that we can't travel back in time. We can't do anything ex post facto where we're subverting contract obligations. Moving forward after a certain point, the concept as it was originally drafted was to make the county lien the highest priority lien on newly produced minerals, which again don't come into existence until that moment, and that's when the lien can occur. I've actually wondered why accept any superior lien existing before January 1st, 2021 honestly even makes a difference. And this is something I guess I'll just ask. We are trying to put a lien on a material as soon as it comes into existence, right? That very moment. The idea that somehow somebody else has a lien on it prior to it coming into existence when it hasn't existed yet is interesting. I guess they do, but what we're trying to say is we're going to get in position first and others come afterwards. So I honestly don't necessarily see where we would be causing any sort of a contract problem, because I'm trying to wrap my mind around exactly how that works in the first place and was when we were working this. But in my opinion, though, striking except any superior lien existing before January 1st, 2021 in that C paragraph really is just fine and doesn't subvert any prior contracts in my mind. And that was how I felt about it as we were working it Senate side and through the select committee.
Well, Senator Rothfuss, to that point, if I loan $5 million to a company to grow well, and I'll take my security interest on their current future production. And that's legitimate. Just same way, I take a security interest on all calves that are going to come out of a cow during her lifetime. So that's why.
Mr. Chairman, on that point,
and that's been the debate on this, Jeremiah, is money was lent before these statutes came into existence under a set of circumstances, and we're trying to change those with statute for all future financing or refinancing and new companies that come in to existence. The new law comes in place and counties are better off than they were before. I have a real concern knowing how difficult these were to get through the legislature over the years of seeing this go through with this in there. So I guess I want to understand why you think you're in a worse position, or we've gained no ground here with it.
Mr. Chairman, what I'm trying to relate is that we had heard those concerns in 2019 and worked with the bankers to allow for space for them to work with their crediting entities until that date on January 1st, 2021, at which point in time the counties would then assume a superior position related to bankruptcy transactions. And that's important, particularly if we're trying to address, and as some have said, this is the most critical component of all of the ad valorem elements to ensure that if a company does go bankrupt, that the county is not the last entity on the list, as we have seen with various decisions in Wyoming against what we've seen in other states. Let's just take Montana, for example, in the most recent Campbell County case, where Wyoming or Campbell County was unable to collect, but Montana counties were given priority position. So the concern is that with this provision in here, that for that period of time, which creditors have a lien before January 1st, 2021, the county is always going to be behind them. And in some instances, that may be a decade or more into the future. So there is concern that without removing this provision, that the counties are no better off than they were before these statutes. And I'm not trying to be critical of the good work here. Please don't take it that way. We're incredibly appreciative of the progress we have made, but this is one of the underlying concerns that still remains.
Okay. All right. Any further questions on that particular issue, committee? Okay. Then Jeremiah, let's go ahead and tackle that last issue. I think you probably listened to the question I asked of Mr. Fuller. So I think we just need to make sure we got the right path forward here.
Yeah, Mr. Chairman, again, this is an issue that the treasurer's brought to our attention. So I am giving this a bit third hand, and it'd be good to have them as part of this conversation. But again, what you have here are perhaps two conflicting provisions in the same section of statute where we say pursuant to the tax sale provisions of existing statute, which is what that subsection E references to. Right. And again, as you
Jeremiah, I'm going to interrupt you. I'm
yeah,
sorry.
please.
Senator Wasserberger had a question, so okay. But we take that before you get rolling.
Thank you, Mr. Chairman. I just listening to the debate on this issue. I'm wondering if this would be appropriate at this time to request an Attorney General's opinion on just exactly what primacies the counties would have under this statute.
Which one, Senator? Which section?
The liens.
The date of the lien, is that?
Yes.
Okay. Yeah, I don't know.
I mean, it seems, Mr. Chairman, it seems to me that there's confusion between the county commissioner's position and other attorneys and experts on this issue.
Well, yeah, I guess we can explore that. I don't think there's confusion. I think it's just a policy decision.
Okay.
Yeah, but yeah, we can discuss that. Sure. Okay, go ahead, Mr. Freeman.
Yeah, Mr. Chairman, what I was going to relate is that provision also then includes a number of other responsibilities of the county treasurer relative to these foreclosures. And I apologize, you do need to go to Senate File 139 to find the full list of those, and I know those were included in the materials. They start on page 6 in large Romanet I and go through the end of page 8. And as I understood it, there are perhaps some conflicting provisions and a number of additional steps that a county treasurer will have to go through in order to pursue a foreclosure that are presented by both of these provisions. So the simple request was to take out the tax sale portion of this statute.
So if we take out the tax sale portion, how do they get to a sale of the asset? How do they get the money? Because what's in the statute from last year is just notice of intent.
Mr. Chairman, as I understand it, they would rely on the existing statute, which in part would include that tax sale provision. But it would certainly be valuable for us to have the treasurers as part of this conversation. I know they were originally scheduled, and I know they're off of the agenda, but this is an issue that they brought to us.
Yeah, Senator Coe.
Yeah, thank you, Mr. Chairman. So a question for you, Jeremiah or Bill or anybody. Do you support striking the language in paragraph E? I mean, does the County Commissioners Association support striking the language in paragraph E on page 5?
Mr. Chairman, Senator Coe, to the extent that it helps the county treasurers pursue foreclosures of entities, then yes, we would support that strike. if it's simply a choice between two processes, we'll certainly work with the committee on the most appropriate one to select.
Mr. Chair, if I could address Senator Coe.
Oh, yeah, go ahead, Bill, yeah.
Senator Coe, yes, we would support it. And when you get into these situations, the action itself is usually not undertaken by the county commissioners. The treasurer becomes the party, and in that capacity is not only representing the interests of the county, they're also interests of the school districts, the special districts, essentially anybody that has taxing authority within that jurisdiction. So, you know, when we envision a tax sale that the treasurer does, that is typically more appropriate for folks who get behind on their real estate, and typically the bank holding the mortgage is going to come in and escrow that and make sure that those get paid, so you never ever end up at the tax sale. So I do think it would be appropriate to go ahead and strike this, and I guess I'd defer if Barry has any more, because he does advise our treasurer on all these matters.
Okay, yeah, go ahead, Mr. Crago, if you got a comment. I'd just like to know, how do you get to your money? Because what's in existing statute is nothing more than a notice requirement.
Thank you, Mr. Chairman. I think, as Jeremiah said, there are provisions in there to go attempt to collect the taxes. I guess, reading this language, what caused me concern, I guess, as counsel also for our county treasurer, is it forecloses our options to, and the way I read it is, it forecloses our options only to a tax sale. And there are other options, for instance, bringing a suit. We have, for instance, we just did one here in the county just a couple weeks ago. And so we just filed a lawsuit to foreclose the lien in district court. And so that's different than a tax sale. And I actually like the language regarding the ability to use the tax sale. I just think the clause right where it's inserted in the statute is probably the wrong place. I agree with you that I would love to have language in the statute saying we can use the tax sale provisions specifically for mineral liens. I think that would be great. I just think the clause where it's inserted right there makes it sound or look like that's our only option. And I think the treasurers were worried that it sort of painted them into a corner as to their options for collecting those taxes. They, you know, tax sales are not the only option, if that makes sense.
It does, yeah. I'm just, you know, and I know the discussion on this was in the existing statute is how do you get from notice of intent, in notice of delinquency, and then you're basically putting your notice of intent to file on the lien, is then if it is silent as to what your options are, you feel comfortable that you have the remedies at law to be able to collect. I guess that's the question.
Mr. Chairman, we do feel that way based on current statute. Yes, sir.
Okay. Mr. Fuller, you popped on the screen. Go ahead.
Yeah, Mr. Chairman, and maybe just to add a little bit to this discussion, on Senate File 139, so on the copy that was posted, would be on page 7. It's subparagraph F, and it reads, "No other action beyond that described in subparagraph E shall be required to foreclose a tax lien." You know, that seems like it would contemplate, you know, the only prerequisites to foreclosing on a tax lien would be that notice of intent to foreclose, after which, you know, the question would be, you know, does that language in subparagraph E, intro, limit it to a tax sale? I think ultimately that's a matter of policy for the committee to decide, but I just wanted to note that language in F as the committee's discussing this issue.
Yeah, no, and this is nothing more than we were, I know when we were discussing this, is how did we get to a remedy? And they have, your organization as one that has to deal with this is saying that you have remedies available at law and you don't need to have this in there. It doesn't bother me at all. I just just want to make sure we've thought this all the way through. And Jeremiah, when you were saying, well, this was brought by the assessors, we weren't completely sure, that made me nervous, okay? Yeah, any further comment on that?
No, Mr. Chairman, those are the three changes that we have for you today.
Okay, all right. Who on this committee was on that task force? Was it Senator Wassenberger and Senator Rothfuss? Just Senator Rothfuss was on that. Okay. Yeah, I just know it was really difficult getting that bill through last year. We had to do some substantial work to it. Okay. Any questions for Mr. Ryman, Craigo, or Mr. Novotny, Commissioner Novotny? Okay, Jeremiah, if you guys can hang around, we'll do we have we'll see who else is here to testify on this. I do know that we had Pete Obermuller, Travis Detai were signed up to testify. Are they?
And Mr. Chairman, they're both in the room. They just have their cameras off.
Okay, so this I got Mr. Obermuller's first on my list, so we'll just go that way. Yep, go ahead.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Pete Obermuller, President, Petroleum Association of Wyoming. Mr. Chairman, I don't have testimony on this. I was hanging out in the room in case there were questions for me, but I don't have further comments.
Okay, Mr. Obermuller, what about what discussions have your members had regarding? I'm more interested on the change, the January 1, 2021. Making all these ad valorem liens superior. Has that been a discussion? Was that a discussion amongst your members? May affect their financing?
Mr. Chairman, appreciate the question. Really, it's no different than the discussion prior to the 2019 session of the Wyoming legislature and the 2020 session, which was we felt like and still do feel like that the making sure that the lien priority laws are in good shape and enforceable do a lot more to insulating Wyoming and their counties from delinquencies and unpaid taxes than any of the other efforts that were out there. So we continue to believe that. In terms of the financing, we discussed that at length prior to the 2019 effort, and ultimately came to the decision that it wasn't an issue that we were concerned about. And leading into 2020 and into this discussion today, my members have not talked to me about that any further.
Okay. Meaning your members wouldn't be concerned if that language was struck? Or meaning they would be concerned?
Mr. Chairman, you mean the language on tax sales, or what other, or the language that delineates 2021 and pre and post 2021?
Yeah, the pre and post 2021.
Yeah, Mr. Chairman, just as a general reference to contracts and government involvement in contracts, I think the effort that your effort and Senator Perkins, President Perkins' efforts to clearly delineate that makes a lot of sense. But to be perfectly fair, my members have not mentioned to me about, have talked to me about that issue.
Okay, all right. Representative Duncan, did you have a question? Okay, you're good. Members, any questions for Mr. Obermuller? Anything further? Okay, that was much easier than yesterday.
Thanks, Mr. Chairman.
Okay, Mr. Detai.
Good morning, Mr. Chairman. Travis Detai with the Wyoming Mining Association. I would just go back a couple of years. My membership and our organization felt very strongly that given the county's lien priority, superiority would be a tool in their toolbox to help collect delinquent taxes. We continue to feel that way, and don't have any position on the bill, but we would certainly support any efforts to give the counties that tool in the toolbox.
Okay. All right. Any questions for Mr. Detai? So I got every time. Oh, go ahead, Representative Duncan.
Thank you, Mr. Chairman. I just want the same question asked to Mr. Detai. do you have any concerns or issues with this this assumption of us in getting in the way of contracts that are prior to the 2021?
Mr. Chairman, Representative Duncan, that has not come up in discussions with my members.
Okay. All right. So, yeah, Representative McGuire.
Thank you, Mr. Chairman. I guess my question would be for both the Mining Association and the petroleum producers. Have you discussed it with the legal counsel for your members? Because any change in this, this particular statute has been highly litigated in the past. This is a very complicated, you pull one string and 20 other things change. And so I would encourage, before we get any statements that it's not concerning, I would encourage you to make sure that this has been fully vetted, because again, I would say that probably their legal counsel would be more than concerned if they started looking at it. Just an opinion. Thank you, Mr. Chairman.
Mr. Detail, any comment on that?
Mr. Chairman, Representative, we could certainly have those discussions, but as it is right now, nothing has come up from my membership, but we can certainly initiate those conversations.
Mr. Obermuller?
Mr. Chairman, Representative McGuire, I appreciate that. And as I'm sure you can appreciate, engaging with the legal counsel of every one of my members will give you about 200 different opinions about how this is going to happen. So that's a difficult question, but I will say that we had that discussion and had it very seriously prior to the major change in 2019 that you all have been trying to correct, make work a little bit better since then. So from our standpoint, it's a policy decision at the end of the day for this committee and for the legislature about the demarcation between pre and post 2021. From our position, dating back just personally, I started agitating for a change to this back in 2014. And had we made that change then we'd be 5 years into this, and we would be, you have to start somewhere to make that change. And affecting contracts, to your point, Representative McGuire, is a big deal. But we had that debate in 2019 in my association, and that hasn't changed.
Senator Rothfuss.
Thank you, Mr. Chairman. Mr. Chairman, I think there was some debate in the House that honestly I'm not familiar with, and who was really pushing strongly back against this and wanted the date written the way it was, because I haven't heard industry or public testimony pushing back strongly on it. I have on the idea that we would retroactively change past mineral lien priority, right? But the future lien priority, again, seems like it's within the purview of the legislature. I still really believe that we get to make laws, and part of the risk assessment that banks and contracts have to take into consideration is that laws will change. I don't think we're obligated to make sure that every past contract ever passed still stands with regard to Wyoming statute. That's not really on us. We can't quash those prior contracts, but we can certainly change statute on things like lien priority. So who were we hearing from that pushed back on that?
Well, I disagree with your statements. I don't think that we should pass laws that go back and contradict prior contracts. And so, what is absent on this call or this meeting is the Wyoming Bankers Association and those industries that are out there with financing in place that may be in jeopardy with a significant change like this. That's who we're missing on this call or in this meeting. So, Representative Duncan.
Thank you, Mr. Chairman. My concern is this is a big deal, because if you are going to take an agreed to signed agreement contract that's valid and you're going to all of a sudden change it arbitrarily halfway through or even a part way through with the parties didn't agree to that. That's a big deal. It would be different if the parties agreed to that, and the parties agreed to the change that the bankers and the county and the mining industry, you know, the mine, they agreed that the county could be superior, retroactive, but and go back in time. But for the county to all of a sudden be thrust to the front and the bank had no say so, that's a total violation when they didn't have a say so. And that was an agreement and signed to by the bank and the mining company. So for us as the state or us as the county to supersede that agreement, that's wrong. So that's where I have a problem with it.
Okay, Senator Rothfuss.
Thanks. I just wanted to follow up on that. I mean, that's not what the contract says. The contract doesn't lay out a list of lien priorities with a position for the state. The contract is a loan that has an assumption of a lien priority for the entity that's engaging in the credit operation with the state. And they do assume, based on past practices, that the state will have an inferior position to the creditors. That's true. But the idea that we're going into that contract and rewriting some portion of the contract as the state and lining it out, that's just not the case. The contract is still the same contract that's written because the state is not a party to that contract. Now, the idea of going back again on minerals previously produced, I see these points as being very strong and valid. But again, I just haven't seen anyone saying that. So if you know, here's an example: a 1950s contract that someone wrote to continue to provide credit for an operation, 1950s. And the idea that somehow a change in law now, well, I'm sorry, we can't change the law because there's a 1950s contract between two parties. You know, the idea that we're inhibited by this, we can have a date set point in the future. These businesses will understand that risks may change. They could renegotiate based on that. I think it was thoughtful that we had a point out in the future where if the risk changes sufficiently, that somebody needs to change the credit, that's just fine. And I assure you, every last one of those contracts probably has some provision to allow for that renegotiation. But again, the idea that the state needs to just back away from trying to reclaim tens of millions of dollars and assert our appropriate priority because somebody somewhere out there may have a contract in place, you know, there's a line somewhere that needs to be drawn, and we just don't seem to be at all in an unreasonable place. And I don't see the bankers here. They know where we're at. They show up. Why aren't they objecting to this? I don't see creditors here. Why aren't they objecting to this? They know this is on the agenda.
Yeah,
I want to hear from them.
They will be. They will be. Representative Furphy.
Thank you, Mr. Chairman. Well, the bankers aren't here because we thought we had a clear deal that until January 1st, 2021, they could make loans and their liens would be valid. And they knew after that period of time, okay, liens would be in a second position to the counties after that period of time for production. So the bankers just need to know a date. Liens are not perpetual. So you can't go back to 1950 and have a lien that you placed on it. Mortgages are different. That's mortgage on the land. But liens on production are limited to period of time. And most of them are for operating capital mining company. And so typically a year or two loan secured by a lien, and they know how they're going to get repaid that working capital loan from the production. So I'm just saying the bankers thought we had a deal. And if we're changing the deal, you're going to hear from the bankers But I just wanted to make that clear. So thank you, Mr. Chairman.
Yep. Representative McGuire, do you have your hand up? Where'd you go on my screen? There.
Thank you, Mr. Chairman. And since we're in the discussion phase, I would just interject that, in my opinion, especially at this time, we don't want to do anything that creates an additional chilling effect on further investment or further development of our minerals here in the state of Wyoming. And we're dealing with not just the bankers, we're dealing with people who have equipment financing. We've got subcontractors. We've got many, many people who have security interests. And to say that, well, in their agreements, they have the ability to renegotiate. No, I don't think so. If I went out, if I'm a miner or an oil producer or whatever, and I have a lease to purchase on a piece of equipment, and it's 300 feet down in a hole, you know, how are you going to renegotiate that? And when I made that agreement, I knew exactly what my lien interest was and where my priority was. It's not something that you guess about. You go and take a look at, and it's just like any other, whoever's extending credit, you, especially on a large item, you know exactly what your priority is. And for us to go about and start changing it, and I know we're not so, well, I guess in committee we can use it, but if you look in the green books, again, this is not a piece of statute that has been unlitigated in the past. There are 4 pages of annotations. There's 4 pages of case law that are referred to in this. This is a very complicated thing. And if we're going to make a change, we need to know exactly what the policy is, and then we need to see in context exactly how the statute is going to change. And, you know, honestly, we just need to have it in a better prepared manner so that we can discuss the policy, what it's going to do, and then we can take a look exactly at the language, and we can let these other entities vet it. You know, just to say, well, the bankers aren't here, so they don't care about it. I don't think that's a fair statement. And we've got a lot of other security holders, and they need to have an opportunity to take a look at it and know exactly what's going to happen, because when they made that loan, they did it in good faith based on what their priority was. And it's, you know, it gets back to the takings clause of the Constitution. I think it would be very unfair for us to change what's going to happen to a private entity. So, thank you, Mr. Chairman.
Okay, all right. We were up with Mr. Detai. Any more questions for Mr. Detai? Okay. Is there anyone else in the waiting room, Brian? I didn't see anybody to testify on this particular issue.
Yeah, Mr. Chairman, that's all we had for signups.
Okay. All right. Well, with that, I'll close testimony on this. What is the committee's pleasure? Do we wish to have a bill draft and we can continue on our debate and discussion at a later date if we decide to have a bill draft? So, Senator Rothfuss.
Thanks, Mr. Chairman. I think it would be worth more debate and to understand and to make sure that we have the bankers here, the creditors here, and to have this conversation out. And I don't know whether it's going to be appropriate for the special session coming up or whether this would be something for the general session. But I do think that we should have a bill draft.
Okay, so I take that as a motion for a bill
Yeah,
draft.
I'll make a motion to get that drafted for further consideration by the committee.
Okay, and that would be along the lines of what has been presented by LSO?
Yes, Mr. Chairman, and certainly with more flexibility on the drafting.
Yeah. Okay. Second by Senator Wasserberger. Okay. Any further discussion, committee? Representative Henderson.
Thank you, Mr. Chairman. we've listened for several minutes here and had a lot of good discussion. And I'm not adverse to a bill draft. I'm just saying, I'm asking myself, what's broken here that we're trying to fix? If someone could articulate that, that sure would help. Thank you.
So this is what I see. And I think I was convinced. So the change on page 5, that by striking that language, we're actually giving more flexibility in terms of access to remedies. And I think that's appropriate. I think the language struck on page 3 and then on the bottom of page 4, in my opinion, is fine. If it's struck, it seems like that's a workable path forward and probably a good cleanup. I think the key policy issue that we will address for maybe about the 5th time since I've been in the legislature will be this delineation on January 1, 2021, which we can continue as a committee to debate. Senator Rothfuss.
Thank you, Mr. Chairman. And there may be an alternative to that approach. If what we're hearing is that all of these are relatively short term anyway, maybe you have a date certain a little further out in the future or something along those lines that's a little further out than any of these liens would have. In other words, let change the policy definitively, but preclude the possibility of these long-term liens or something hanging over. There might be some alternatives to this. All we've looked at so far is basically a starting point. I don't think creativity in this area has been explored.
So I think that's a good point. I know with items of personal property, you're looking at 5-year perfection on your liens. Real estate obviously can go on for much longer. And I don't know about mineral production. If that falls within a 5-year window, that's all we're talking about.
Right.
5 years.
And that's helpful to know.
And we can explore that. And I think, in fact, we can probably ask Mr. Fuller to look at that for us. So,
yeah, I think that's a good idea. Thanks.
Any further discussion on this committee? So the motion before us is to get a bill draft, which we will then take up at our next meeting. Do not see any way, shape, or form, or even want to try to have this teed up for a special session. This will have to wait till the general session. Okay. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7. Those opposed. 1, 2, 3, 4, 5, 6. All right. Well, that will send a signal there, committee members. So we will get a bill draft. We will consider this at our next meeting, and it will be what it will be. Okay. All right, folks, we're a little behind schedule. Is anybody opposed to coming back in at 1 o'clock? Is that plenty of time for lunch for everybody? Okay. While we do this recess till 1 o'clock, at which time we'll then get our reports from DEQ. And I see Director Parfit's been patiently waiting, but unfortunately, he'll have to wait a little bit longer. So, okay. All right. See you everybody at 1.